Morning, everyone can be seated.
Morning, Judge.
Before I ran the jury instructions for both the jurors and the parties, did anyone have anything to raise concerning them?
Yes, Your Honor, very briefly, and I apologize for not emailing you over the weekend.
I was about to ask why this didn't happen, but go ahead.
It's a long weekend, Your Honor. So just minor, on page 2, under 3.5b, it says to be the last sentence says to be a principal, the defendant does not have to be present when the crime is committed or attempted. It is a correct statement of the law, but I wonder if we need or attempted to be consistent because we've taken out attempted in other areas.
Right. State, do you have a position concerning this edit?
No, sir.
Very well. I don't believe there are any attempts that are a part of the charged offenses, just completed offenses, so I will remove attempted. Is there anything else?
2 more, Your Honor. One is just a typographical. On page 4, under 3.7, in the first paragraph, 3rd line down, it reads information. I think it should read indictment.
Yes.
And then lastly, on page 7, under verdict, it refers, 3.12, it is the standard instruction, but it refers to lesser included, and since the parties have waived lesser included, I think perhaps the first paragraph ought to come out. And I think that for the second paragraph...
I would believe it would just read, you may find the defendant guilty as charged or not guilty.
Yes, that's fine, Your Honor.
All right, go ahead.
And then the second paragraph, the first sentence has a clause which reads, it should be for the highest offense on the verdict form. I think perhaps you could take out highest.
State, do you wish to be heard as to any of these other edits?
No, Your Honor.
All right, it's going to take a few minutes to go through this, which is why I wanted you to email me. However, we'll get started as soon as this is done. Is there anything else that we need to address?
Judge, the state has provided a laptop for the use in the jury room. It does not have anything on it. It does not have internet access. It's available for inspection if anyone wants to do that. But it's our thought that they would be provided with the headphones that are out here. The other equipment is already back there, and this laptop for their use while reviewing the evidence.
Does the defense have a position concerning this?
No, Your Honor.
Very well. It will be sent back. Any other issues?
Nothing from the state.
Right, I'll email you those changes, and from there, you won't need a verdict form, but we'll need 17. Using the restroom?
They're ready.
Okay.
I got it. Take this one. Anything important? Yep. No, it's good.
Good.
Couple of them did ask where the chicken was. I said, well, I ain't got no control over that.
Can't help you there.
That didn't make any sense. I don't want to break their law. I don't want to break their law.
I agree about lunch, but probably.
Yeah, of course.
Before. It's up to the judge's discretion, but typically yes.
Smart.
Started with bringing in the jurors and moving the instructions.
Your wife has it.
Court back in session.
Everyone can be seated. You can pass those out. For everyone in the gallery, I just wanted to give a reminder once again, as the closing arguments are taking place, do not make any gestures, do not shake your head that you're in agreement or disagreement. Please silence your devices, and also as well, do not have any cameras that are pointed at either the jury or the litigants. And just put the 15 in the seats. Please get it on silent now.
All right, jury.
Everyone can be seated. Members of the jury, good morning. Good morning. Now that the evidence has closed in the case, I am going to be giving you your instructions on the law itself. A copy of the jury instructions that I will be reading to you has been placed in your chairs. If you wish to follow along as I read to you, that is certainly your choice. If you just wish to listen as I read it out loud, you may do so as well. After these instructions have been given, the attorneys are going to give you their closing arguments. Let's get started at Header 3.1, Introduction to Final Instructions. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I am about to give you. Charles Adelson, the defendant in this case, has been accused of first-degree murder, conspiracy to commit first-degree murder, and solicitation to commit first-degree murder. Charles Adelson is accused of first-degree murder in count 1 of the indictment. I will now instruct you on the circumstances that must be proved before Charles Adelson may be found guilty of first-degree murder. To prove the crime of first-degree premeditated murder, the state must prove the following 3 elements beyond a reasonable doubt. Element 1, Daniel Markel is dead. Element 2. The death was caused by the criminal act of Charles Adelson. Element 3. There was a premeditated killing of Daniel Markel. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. If the defendant helped another person or persons commit a crime, the defendant is a principal and must be treated as if he had done all the things the other person or persons did if the defendant had a conscious intent that the criminal act be done, and the defendant did some act or said some word which was intended to, and which did incite, cause, encourage, assist, or advise the other person or persons to actually commit the crime. To be a principal, the defendant does not have to be present when the crime is committed. If the defendant paid or promised to pay another person or persons to commit a crime, the defendant is a principal and must be treated as if he had done all of the things the person who was promised or received the money did if the defendant had a conscious intent that the criminal act be done, and he made or promised the payment in exchange for the commission or promised to commit the crime or to help commit the crime, and the crime was committed by Sigfredo Garcia and or Luis Rivera. To be a principal, the defendant does not have to be present when the crime is committed. To prove the crime of criminal conspiracy, the state must prove the following two elements beyond a reasonable doubt. The intent of Charles Adelson was that the offense of first-degree murder would be committed. In order to carry out the intent, Charles Adelson agreed, conspired, combined, or confederated with Katherine Magbanua and or other co-conspirators to cause the first-degree murder to be committed either by them or one of them or by some other person. It is not necessary that the agreement, conspiracy, combination, or confederation to commit first-degree murder be expressed in any particular words or that words pass between the conspirators. It is not necessary that the defendant do any act in furtherance of the offense conspired. To prove the crime of criminal solicitation, the state must prove the following two elements beyond a reasonable doubt. Element 1. Charles Adelson solicited Katherine Magbanua, Sigfredo Garcia, and or Luis Rivera to commit first-degree murder. Element 2. During the solicitation, Charles Adelson commanded, encouraged, hired, or requested Katherine Magbanua, Sigfredo Garcia, and or Luis Rivera to engage in specific conduct which would constitute the commission of first-degree murder. It is not necessary that the defendant do any act in furtherance of the offense solicited. The crime of first-degree murder has been previously defined in these instructions. To solicit means to ask earnestly or to try to induce another person to engage in specific conduct. The intent with which an act is done is an operation of the mind and therefore is not always capable of direct and positive proof. It may be established by circumstantial evidence like any other fact in a case. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the indictment through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial, and to it alone, that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: did the witness seem to have an opportunity to see and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's questions? Did the witness have some interest in how the case should be decided? Does the witness's testimony agree with the other testimony and other evidence in the case? Has the witness been offered or received any money, preferred treatment, or other benefit in order to get this witness to testify? Had any pressure or threat been used against the witness that affected the truth of the witness's testimony? Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Has the witness been convicted of a felony? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like any other witness, with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. You must consider the testimony of some witnesses with more caution than others. For example, a witness who claims to have helped the defendant commit a crime, has been promised immunity from prosecution, or hopes to gain more favorable treatment in her own case, may have a reason to make a false statement in order to strike a good bargain with the state. This is particularly true when there is no other evidence tending to agree with what the witness says about the defendant. So while a witness of that kind may be entirely truthful when testifying, you should consider his or her testimony with more caution than the testimony of other witnesses. However, if the testimony of such a witness convinces you beyond a reasonable doubt of the defendant's guilt, or the other evidence in the case does so, then you should find the defendant guilty. The defendant in this case has become a witness. You should apply the same rules to consideration of his testimony that you apply to the testimony of other witnesses. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. There are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. Number 1, you must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. Number 2, this case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits and evidence and these instructions. Number 3, this case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. Number 4, remember the lawyers are not on trial. Your feelings about them should not influence your decision in this case. Number 5, your duty is to determine if the defendant has been proven guilty or not in accord with the law. It will be my job to determine a proper sentence if the defendant is found guilty. Number 6, whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. Number 7, your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. A separate crime is charged in each count of the indictment, and although they have been tried together, each crime and the evidence applicable to it must be considered separately and a separate verdict returned as to each. A finding of guilty or not guilty as to one crime must not affect your verdict as to the other crimes charged. You may find the defendant guilty as charged or not guilty. If you return a verdict of guilty, it should be for the offense on the verdict form that has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to the crime charged. The verdict must be in writing, and for your convenience, the necessary verdict form has been prepared for you. It is as follows. And there is actually only one verdict form because we're not going to introduce chaos into the case, but I will read it to you now. State of Florida versus Charles Adelson, case number 2016 CF 3036B. We, the jury, find as follows as to count 1 of the indictment, first-degree murder. Check only one letter choice as to this count. Option A, the defendant is guilty of first-degree murder. Option B, the defendant is not guilty as to count 1. Count 2. We, the jury, find as follows as to count 2 of the indictment, conspiracy to commit first-degree murder. Check only one letter choice as to this count. Option A, the defendant is guilty of conspiracy to commit first-degree murder. Option B, the defendant is not guilty as to count 2. Count 3. We, the jury, find as follows as to count 3 of the indictment. Solicitation to commit first-degree murder. Check only one letter choice as to this count. Option A, the defendant is guilty of solicitation to commit first-degree murder. Option B, the defendant is not guilty as to count 3. And that is to be signed and dated by the individual who will serve as the foreperson. Both the state and the defendant have now rested their cases. The attorneys will now present their final arguments. Please remember that what the attorneys say is not evidence or your instruction on the law. However, do listen closely to their arguments. They are intended to aid you in understanding the case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defense has given its closing argument. Whether or not you take notes, you should rely on your memory of the evidence, and you should not be unduly influenced by the notes of other jurors. Notes are not entitled to any greater weight than each juror's memory of the evidence. Is the state prepared to give its closing?
Yes, Your Honor.
You may proceed.
May it please the court. In jury selection, we talked about the burden of proof and how it was my burden to prove this case to you beyond a reasonable doubt through evidence. And generally speaking, the defense's job is to poke holes in the evidence and argue that it falls short of meeting that high burden. And we also learned at jury selection that the defense does not have to prove anything. But sometimes if the law enforcement investigation is so thorough and so compelling that there's really no way to poke holes in the evidence, he has to basically admit his own words, his own text messages. That stuff is undeniable, right? And those things prove that he was in cahoots with Katherine Magbanua in 2013, through the murder in 2014, and all the way up until her arrest in October of 2016. He knows he can't deny that he paid the killers because of this bizarre practice he had of stapling his money. So sometimes when a defendant can't attack the facts or the law, they instead try to explain it away by saying, you can't trust what you're seeing. It's not what it appears to be. It's actually something else entirely. Often, as in this case, the individual explanation, so when you zoom in on one piece of evidence with its attached explanation, can be like, maybe. But when you zoom out and you add all these things together, this explanation, and this explanation, and this explanation, this coincidence, and this coincidence, and this coincidence, it starts making less and less sense. It starts being less and less reasonable. And when you zoom out from the defense's theory, it's really unreasonable, right? Because to find it reasonable, you have to buy a lot of things that he's selling. The most obvious of which is that because Sigfredo Garcia hated him, he and Rivera traveled to Tallahassee twice to kill someone he hated in hopes that he would give them money for it on the back end. Please think about that. To hit this defendant where it hurts, These two dudes, with no connection at all to Dan Markel, and without 2 nickels to rub together, rented a car and paid for gas to come to Tallahassee and stay in a hotel twice in order to kill someone that this defendant hated, to harm him. And for what? To maybe get money. Maybe he just turns him in for murder. Why not just kill and rob him if what you're after is money and there's no hired hit? Why not just kill and rob him if your motive is, we hate him? Then the bad guys don't even have any contact with him, according to his own story. They didn't threaten him, they did not beat him into submission. Instead, they sent his own girlfriend to extort him on their behalf. And without any actual contact from the bad guys, the defendant just opened up his safe and handed over his beloved money that he had saved his entire life since he was a child. He just handed it over. Take it all. And when that amount wasn't sufficient, these stone-cold murdering gangsters let the defendant go on a payment plan to give him the rest of the money. They let Katherine Magbanua skim off the top each month. And never, over the next 2 years that he was being extorted monthly, these gangsters, remember that money doesn't go to the principal, that $3,000 a month. They never show up to demand the remaining $195,000 that this defendant has agreed to pay them. Then, you also need to find reasonable that over the 2 years of this supposed extortion layaway plan, that the defendant continued to do what? Send these kissy faces and love texts to Katherine Magbanua. He's sending these messages to a woman who got him into this mess, and he says he didn't suspect she was involved. What? What do we know about this man? He didn't suspect she was involved. She's taking the money. He's never even heard from the bad guys. He didn't see it that way, that she got him into this mess. They grew closer after she began extorting him for $3,000 a month. Meanwhile, the defendant and Katherine Magbanua break up. She continues to maintain her direct and indirect contact with Sigfredo Garcia, the man who's extorting him, the man who murdered his former brother-in-law in cold blood. But he sees her as a friend. The kissy faces and the I love yous continue. Even after Katherine Magbanua got back together with the man who executed Dan Markel, the father of his young nephews, and a guy who's actively extorting him, this defendant continued to reach out to her over and over again to offer her favors and gifts, including a birthday gift for Garcia, and to tell her he loves her and how lucky he is to have her in his life. Lucky? Next, to find a reasonable doubt here, you have to find it reasonable that the defendant never texted or talked about this first layer of extortion. Why? According to him, because Katherine Magbanua said, let's never talk about this. So they didn't. Then you have to believe he never reported or revealed this information to law enforcement out of fear of the gangsters. And finally, you have to believe that this living in fear of death by gang members over 2 years didn't cause a change in his general demeanor that his friends noticed, but later the bump from law enforcement did. He says that's because, well, I became worried that I might be falsely arrested. So I wasn't a hot mess when I was being extorted by gang members and threatened to be killed and my whole family killed. But I became a hot mess when I started to get worried that the cops might be getting closer. And I have no real way of knowing if all this stuff sounds ridiculous to you, if it sounds reasonable to you, or if y'all just heard so much stuff that you're totally confused and can't even remember what the evidence in the case showed. But they only need to get one of you confused enough to derail this whole thing, right? So I've got to go through each thing with you. Your verdict has to be unanimous. So I want to go through the testimony, I want to review the evidence, and I want to spend a little bit more time talking about this multitude of explanations the defense has offered in an effort to really turn each piece of evidence on its head. This is Dan Markel. He is the victim in this case. A brilliant lawyer, a funny guy, a son, a colleague, a brother, a mentor, and a friend. But most of all, a father. A dedicated and loving father whose downfall was brought about by the fact that his number one priority was maximizing his access to those two little boys in the wake of a bitter divorce from their mother. And despite the defense's efforts to characterize their client as the real victim here, Dan Markel remains the only victim in this case. The only thing he was guilty of is fighting like hell for those kids. And he lost. He didn't lose in court, but he lost. This is what he looked like before this defendant hired a hitman to kill him. And this is what he looked like afterwards. The evidence has shown that on July 18th, 2014, this brilliant man was gunned down in broad daylight in the driveway of his own home. His horrific death ultimately set police down two separate paths following the two most promising leads they had. The first was to chase down that Prius that Mr. Geiger saw fleeing the crime scene. And we'll examine those efforts in detail. The second path was to ask, as we would in any murder investigation, who might want to have done this? Who would want Dan Markel dead? And within 1 hour of the shooting, before Professor Markel was even pronounced dead, this path was already pointing to the defendant. When his sister revealed to law enforcement that her family hated Dan Markel and that her brother, Charlie, had joked about hiring a hitman to kill him. And this trash talk, of course, would be meaningless had he not been killed by a hitman. So who did it appear had a motive to want Dan Markel dead? His own family. And what offense had Mr. Markel committed against these people? Refusing to let his children be taken away from him? Objecting to them disparaging him to his kids? The evidence has shown that the Adelson family was all about psychological warfare. And when all else failed, they were willing to go even further to win. I want to examine this motive in more detail and look at exactly how it's attributable to this defendant. Despite the defense efforts to minimize this, it's really clear that the divorce between Wendi and Danny was a particularly nasty one. They fought over everything, all the way from the children down to the bicycle and the tennis racket. In January of 2013, Wendi Adelson filed a motion to allow her to relocate to South Florida with the kids. They were 2 and 3 at that time. As one basis for this request, Wendi cites the wife's parents reside in Coral Springs and the wife's brother resides 20 minutes away. The children are very close to the wife's parents. Wendi Adelson also alleges in this filing that the husband has also created a hostile work environment for the wife at FSU School of Law. Wendi Adelson viewed herself as stuck in Tallahassee, a characterization which she now denies but one which was used to describe her situation by Jeffrey Lacasse on the witness stand and also in her own pleadings in these divorce filings. In Markel's answer on page 80, he seeks continued equal time sharing in Tallahassee. He seeks sole parental responsibility on issues related to the education, religion, and medical upbringing of the kids. Then we go to this May email from Donna Adelson to Wendi. These emails are offered as examples of how invested Donna Adelson was in this litigation and in Wendi's life in general. They reveal that relocation was a huge priority for Donna and that it was also a high priority for Wendi, Harvey, and the defendant as well. Wendi testified that her mom really wasn't that involved in her divorce proceedings. Again, these emails prove the opposite was true. On May 3rd, 2013, this email references Dan's divorce filing as, quote, his 23-page rant. She then crystallizes the importance of relocation, stating, the most important part of your divorce is relocation, in bold. I since not met her burden of proof that a relocation is in the best interest of the minor children. Like the heroine in her book, Wendi and the boys were officially stuck in this small stop on the way to what we had previously known as civilization. Wendi worked hard to try to convince you that none of this was a very big deal to her, her mother, or her brother. And she said she was expecting to win everything in the divorce. She was expecting Danny to lose everything in the divorce. She was partly right. Danny did end up losing everything, but not in court. She had already lost relocation, and her attorney had to get off the case as a result of whatever Danny was filing in court, and he was poised to really take her through the ringer with this grandma motion, the fraud allegation, and the contempt motion that was all pending. Even if he wasn't going to be successful, folks, it was going to be a very unpleasant ride for Wendi Adelson. But as we have learned, Jibbers hadn't beaten the Adelson family yet. On the stand, Wendi Adelson suggested that relocation was not a big issue for her. It was just suggested by a friend, but the other evidence in the case suggests the opposite. Jeffrey Lacasse said she was a complete mess over the litigation, especially the relocation. She wrote a book about a human rights attorney who was stuck in a small town in the Florida Panhandle because of her hapless Canadian professor husband's job at NFSU. And maybe most importantly, Wendi filed this motion for relocation. Her lawyer didn't file it without her knowing. Was the motion doomed from the start? Wendi clearly hoped not. But there were other ways to skin the cat. Here's a June email from Donna to Wendi. In response to the court order denying relocation, Donna emails Wendi, quote, it's time for action. It's time to take control of your life and not let Jibbers think he's won anything by having you remain in Tallahassee, 8 hours away from the only family you have. Let's show this F blank 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 what will make him absolutely miserable. And later, the rest of your life, and consequently, Dad's, mine, and yes, even Charlie's, will be affected by how well you can perform/act before July 31st. You can be a good actress when you want to. I've seen you in action. You need to put on the performance of your life. Jibbers hasn't beaten the Adelson family yet. Then on June 25th, this is continued, that same email, we get a plan of action. Take a photo of the boys dressed nicely standing at the front door by the sign of a Tallahassee church. They're Jewish, remember? Then change your Facebook status to this one so everyone will see this. Perhaps a line under the photo with "New Beginnings in Tallahassee" might be nice. How happy do you think he will be? Make arrangements to get the boys caught up with a private tutor at the Teenage Catholic Church. who will come to the house to teach the young men about Jesus. If you don't have time to arrange this, I'll be happy to do it for you. Let Jibbers know that your children will be baptized in the Catholic Church, and you'll certainly invite him to the event. I've already checked this out, and the baptism can be arranged within 2 weeks. We can send out evites to Jibbers, his parents, sister, and anyone else you want to invite. 4, I'm looking into summer camp programs for the boys. We will pay for it, even if the boys end up only going for the few days that they're in Tallahassee with you. 5, register them for toddler classes at the church. I've looked into this too. Even if they don't actually go, we can show Jibbers that they are enrolled for the fall semester. And you cannot tell anyone this is an act. Take control from him. Get to him psychologically. He's going to want you to stop this. You have one final opportunity to make him angry. We want him ticked off so he realizes that he could lose control over his kids. We plan to make a financial offer to him to allow this relocation. You need to work this plan, and we'll help you through it so that it may affect how much we offer him. Maybe he's willing to let you relocate if he knew his children could attend this private Hebrew academy. Or perhaps he'd like them to invite him to a Christmas party at their other Sunday school. Let's get this going now. I know you would never want to think that you didn't do absolutely everything you could to come down to your family. Dad and I have changed our lives this year to support you and assist you and the boys in every possible way. Charlie has accepted the loss in the office business income for us to do this because he loves you and wants only the best possible future for you. It's time for you to show us that you can put on the performance of your life for the next few weeks. And then on June 27th, she follows up with another email along the same lines, criticizing the judge and Wendy's attorney and adding, obviously the court isn't out to help you. It's clear since Judge Hobbs' last ruling that she could care less about anything you had to say on your behalf. You need to help yourself. You know, Wendi, most of the wars that have been fought for the last couple of thousand years have been fought over religion. These emails are such telling glimpses into the family dynamics behind this murder. This email is just an example of how relentless Donna Adelson was. And it's clear from these emails that she's conferring with the defendant on these plans that she's proposing. Charlie brought up a good point when he said that Americans were dropped behind enemy lines during World War II wearing Nazi uniforms to get what they wanted. They had a job to get done, and they did what they needed to accomplish it. You have a job to get done in a very short time frame to accomplish it. If you dressed the kids up in Hitler Youth uniforms and brought them down here, I could care less if it was an act of defiance that would show Jibbers that he's not in control. Why not stand up to this fucker? Why not fight? That's all this is, Wendi, an act of defiance that will put a scare into this jackass. It will infuriate him. You need to see the big picture. You need to look into the future of what a life without your only family nearby teaching in Tallahassee, with Danny always in the picture, will give you. It's not a pretty picture. Not everything one has to do in life is comfortable or easy. The extremism that Jibbers is already teaching the boys is nothing more than brainwashing. Religion is brainwashing, control of the masses. I don't think you realize the type of offer we're considering. We're planning on you, Charlie, Dad, and I going as high as equal parts in a $1 million offer. That's $333,000 from each of us. We're a team. We can't do this without your help. You've already lost relocation according to the legal system. Well, it is about winning and losing. We're trying to get a win. You deserve it. You deserve so much more than a life without family teaching in Tallahassee. Even though the divorce was final on July 31st, 2013, the anger and bitterness associated with this split was still festering. Litigation continued and even increased as both parties filed motions over the next several months alleging that the other was violating the marital settlement agreement, and both parties seeking to have the other side held in contempt of court. In October of 2013, Wendi filed a motion to enforce the marital settlement agreement and have Dan held in contempt. And Dan was hearing, and the defendant was hearing about all of this as it went on from his mother, as indicated in the emails and in the text messages shown here as well. Here she's telling him how terrible things are for Wendi and how it's negatively affecting his dad's health. Then later that month, when Wendi was about to make the second dumbest mistake of her life after marrying Dan Markel, by buying a house in Tallahassee, Charlie says Wendi probably hasn't mentioned it to him because it's stupid. And then after he gets Wendi to pull the plug on the house, he's praised as the miracle worker that solved this problem. This text was sent on Halloween of 2013, the very day that Katherine Magbanua testified. This defendant broached the subject to her of, hey, do you know anybody that could rough somebody up? The defendant was hearing about Wendi's situation regularly from Donna. Here we see Donna telling the defendant how angry at Wendi's attorney and stressed out Wendi is. That's on February 15th of 2014. And here's another text from Donna Adelson to Charlie Adelson 4 days later, discussing the details of Danny's actions and expressing how much she hates him. Here on March 4th, 2014, we have Donna planning to speak in private with the defendant while she's at the rest stop in Gainesville. She asks him to delete this message after he reads it. Although he's not with Harvey, and Harvey nor his birthday are mentioned in this text message. All that's mentioned in this text message is, I'm gonna pull over at a rest stop and talk to you in private. This is the grandma motion. On March 26, 2014, less than 4 months prior to this murder, the defendant files his grandma motion, the counter motion for enforcement of marital settlement agreement on parenting issues, and motion for contempt and sanctions. Again, alleging that Wendi is not facilitating communication between he and the kids, and getting after Donna personally. In this filing, Dan Markel alleges that on 3 separate occasions in November of 2013, the children informed him of their maternal grandmother, Donna Adelson, disparaging him. The boys indicate that, quote, "Grandma says you're stupid. She says you are trying to take her sunshines away from her." And, quote, "Grandma says she hates you." Dan Markel requests the court, quote, enjoin the former wife from allowing the maternal grandmother to have unsupervised time with the children, and to impose appropriate limitations to safeguard the children from being subjected to disparaging comments about their father. Contrary to what Wendi Adelson told us, we learned this issue was taken seriously by both sides, and that Dan Markel was particularly hot at the time of his death because of some recent issues that were going on. So to the extent that there was any banana bread peace offering made, it apparently fell short of diffusing the issues within this family. This situation was a pressure cooker, and it was about to blow. As we learned, This grandma motion was never decided by the court because Dan Markel was murdered before it could be heard. Whether or not that is a coincidence in timing is up to you all to decide. Wendi told you that she and Dan were getting along pretty well at the time leading up, or the weeks leading up to his murder. But this assertion does not fit with the rest of the evidence in this case. In fact, her own court filings are completely contrary to that assertion. In addition, her boyfriend at the time, Jeffrey Lacasse, told you all that she took all of this very seriously, that she became upset every time there was a filing, and that her behavior became increasingly emotional and erratic as the time led closer and closer up to what ultimately was the murder day. According to Lacasse, she was especially concerned about the relocation issue. And Stephen Webster, he was Professor Markel's attorney, testified, told us that Markel was irate at the time of his death over two issues. The first being Wendi enrolling one of the kids in a school without consulting him, and the second one being him overhearing Donna Adelson refer to him as stupid on a recent Skype visit that he had with the boys. So this was far from the peaceful situation that Wendi was trying to sell you. Why was she trying to sell you that? Was she trying to protect her brother? She even told law enforcement at her interview on the day of the murder that she wanted everyone held accountable for this to the fullest extent of the law, unless it was her family. The defense seems to be telling you the litigation between Danny and Wendi was not a very big deal because minimizing the litigation minimizes the motive for the Adelson family to want Dan Markel dead. They even called Wendi's attorney to tell you that relocation was a lost cause. But what she actually said was, yes, I lose most of these motions, but in this case, I actually thought there was a chance because of some of the surrounding circumstances. Then I thought, well, maybe they called her to say the divorce was routine, but what she actually said was this case was odd. That was her word. Mainly because Dan Markel came after her personally, forcing her to withdraw from the case, which had never happened before. So what her testimony proved was that this was not a routine, run-of-the-mill divorce proceeding. It was one of her more difficult cases. And she didn't even have Donna in her ear like the defendant did. So the motive was clearly there. The question then becomes, was the defendant successful in distancing himself from that motive in your eyes as jurors? He says that the litigation had no impact on his life. The emails suggest otherwise. He's included on these texts. He's all over the wiretap, meddling in Wendi's life with Donna. Could the defendant have cared enough about his sister's marital problems to commit murder? Maybe, maybe not. But if he didn't, his mom certainly cared enough for both of them. And she was in his ear all the time. In defendant's own words, you can't have a miserable mom. To illustrate this point, I refer you back to the emails and to that phone call that I played that happened before the bump, where Donna and the defendant are discussing this boyfriend of Wendi's at that time, Dave. This call, along with the call about Wendi taking a particular job, which is also on that same exhibit, I think it states 130, was offered as examples to show you how the dynamics work in this family. Wendi appears to be the weakling of the pack. She needs to be protected, she needs to be helped, she needs to be coddled, she needs to be saved by Donna and the defendant. Donna is the overbearing matriarch who nags everyone to death about whatever it is that's currently on her. I call it the wheel. The wheel is turning all the time, right? And Wendi getting away from Dan Markel and moving to South Florida was number one on the wheel. It was the top priority in 2013 and in 2014. And this defendant fancied himself the savior of this family. equal parts black sheep and mama's boy, he would often try to help Wendi at Donna's bidding. When a problem was perceived regarding Wendi's love life, aka this breaking up with Dave situation, shouldn't break up with Dave, Dave's a great guy, Donna enlists the defendant to go in and fix it, to solve the problem. When Wendi didn't know what was best for her regarding a job opportunity, Donna sent the defendant to fix it. And the evidence has shown that Dan Markel was a major problem for Wendi, and that meant he was a major problem for Donna, who in turn made Dan Markel a major problem for this defendant. Enter Katherine Magbanua, who had connections to a criminal element, and she presented an opportunity to the defendant to do what he does and solve this problem. On Halloween 2013, the defendant began the process of soliciting Katherine Magbanua to commit murder. Magbanua solicited Garcia. Garcia brought in Rivera. So if the seed of this conspiracy was planted in the spring of 2013, when Donna was looking into converting the kids to Christianity or making this $1 million offer to Dan Markel, it took root that summer when the relocation was denied and the defendant began, quote, looking into all options to solve the problem of Danny Markel, including hiring a hitman. And the conspiracy grew further still when Dan Markel filed that motion to preclude Donna from having unsupervised contact with the grandkids, the grandma motion. And as Wendi Adelson relayed to Jeffrey Lacoste just 5 days before the murder, she was never going to be able to move to South Florida unless something happened to Danny. This conspiracy spread when the defendant met someone who could actually get this thing done. Someone who was in a position of trust in his life, a person who had connections to the kind of people who, for a price, were willing to point a gun at a complete stranger and pull the trigger. And guess what wasn't a problem once Dan Markel was dead? Relocation. Within a couple days, Wendi and the kids moved to South Florida. She changed the names of Professor Markel's children from Markel to Adelson. And just like that, their father was erased. No more squabbles over kosher diets or visitation schedules. No more death matches over marital assets. No more small town pit stop on the way to nowhere, Tallahassee. No more Dan Markel. And this case may have gone unsolved if not for a few things. Number one was Mr. Geiger. Does anyone other than James Geiger watch out for their neighbors anymore? He heard a loud noise and looked into it because something wasn't right. His observation and description of that Prius was critical to this investigation. It was really the only clue that police had from the crime scene, other than the fact that this appeared to be a targeted hit rather than a robbery attempt. How would law enforcement even start to find a single light-colored Prius? This investigation may have gone nowhere if not for the tireless efforts of law enforcement to cull through all those records you've seen in evidence or heard referenced in this case, including the tower dump, phone records, SunPass records, iClouds, surveillance videos, and so much more, looking for needles in haystacks. And they found a few. One is Garcia's phone number, which was in that tower dump from Premier Gym. And when cross-referenced with all the call detail records of all the Adelson family members, there was a single hit. A call from Garcia to Harvey Adelson on July 1st, 2014. An ill-fated attempt to confront who he thought was his baby mama's new boyfriend, but who turned out to be the father of his baby mama's new boyfriend. And then tracking Garcia's cell phone to match time-wise, a particular sun pass that went through toll plazas at the same time as the phone. That sun pass was identified as being affixed to a particular rental car, Prius, which led to this rental contract bearing the phone numbers of both Luis Rivera and Sigfredo Garcia. Although you're not being asked to decide the guilt of anyone on the screen other than this defendant, it's necessary for you to understand the roles that each played in order to understand how it is that Charlie Adelson fits into this conspiracy. Whatever your thoughts about whether or how much these unindicted players are involved, today's not their trial, and you're not going to be asked to decide anything other than in reference to Charlie Adelson. What is alleged is that the defendant solicited Katherine Magbanua to commit the murder. He conspired with Katherine Magbanua to commit the murder with her, and that the murder was accomplished with the defendant guilty as a principal because he hired and paid for this heinous work to be done. All right, let's see what happens when we follow the Prius. So following the Prius, as we talked about, leads to the rental contract bearing the name of Luis Rivera and the phone numbers of both he and Garcia. Those two led to Katherine Magbanua. Katherine Magbanua led to this defendant. And I want to walk through exactly how we get from this light-colored Prius fleeing the scene to the defendant. Start with Luis Rivera. The defense may seek to discredit his testimony because he's a bad dude. His status as a felon and a gang member are definitely things you should consider when you're weighing his testimony in this case. But please consider that his resume as a bad guy was precisely why he was selected to do this gruesome job. Rivera's gang status made him a more attractive candidate to do this murder with Garcia. In the hot tub in March of 2014, the defendant mentions his connection to a Cuban criminal element. Jeffrey Lacoste reported this within a couple days of the murder when he couldn't have known the ethnicity of the killer. The evidence has shown that the connection the defendant had was through Katherine Magbanua, and the criminal element was, of course, Garcia and Rivera. And we know that at the time defendant made that statement in the hot tub, the plan to kill Dan Markel was already well in the works. That statement was made just 3 months before the killer's first trip to Tallahassee in June of 2014. The statement reveals that the defendant wasn't scared of Katherine Magbanua and her associates. To the contrary, he was boastful. He was bragging about it. He was the big man who was going to solve his little sister's problem, make his mom proud, and get away with it because he was thinking of everything. And he later would say and call JJ that nothing was done improper and suggest that no evidence could be available to tie the killers to him or his family. And he was confident enough of this to brag about it in that hot tub setting, which he thought could never come back to him. He was untouchable. Because if push ever really came to shove, who are you going to believe? An oral surgeon or a gang member? He's banking on that. In regards to Rivera's plea deal, the actual only condition of his plea deal is to tell the truth. And what did he tell us? Katherine Magbanua hired Garcia, and Garcia hired him to do a murder. Why? To help the lady who he understood to be the dentist's sister to get her kids. Aside from fitting with the other evidence in the case, there were a few things that independently corroborated Rivera's testimony. One is that accidental discharge that he told us took place in the rented Prius. This was a fact we didn't know before and were able to confirm upon reinspection of the vehicle. He also told us about the location and timing of the money drop on the morning after the murder at his and Jessica's residence, which was able to be confirmed or corroborated initially by phone records and now also by Katherine Magbanua's testimony. And of course, the phone records confirm Rivera did come to Tallahassee, not just on the July trip, which we knew about, but also on that first June scouting trip or attempted murder trip. The communication records tell us a few other things too. That's the June trip. July, June. This slide shows all the calls between our parties on the night before the shooters made that June trip to Tallahassee. You can see a 25-minute call from Katherine Magbanua to the defendant at 9:17 p.m. on June 2nd, 2014. This call was placed while Katherine Magbanua was consistent with traveling on her way back from Comfort Rental Car, where the first rental car was rented, to her residence. As soon as the defendant hangs up with Katie, he calls his parents' landline and has a 25-minute conversation. On the stand, the defendant was asked about the use of landlines and whether he believed them to be more secure. He testified that on the call he was being asked about at that time that he was talking about switching over to a landline because he was in a place that had bad reception. If there's bad reception in South Florida at a dental office, what about all the other mentions of using a landline that we hear on the wire? Surely he wasn't in a place with bad reception for all those calls. And why call the parents on the landline? Surely they have reception in their South Beach high-rise. In the 2 years of phone records that were examined in this case, the defendant talks to his parents on the landline 28 times, or 0.07% of the times that he talks to them. So mostly on the cell phone by a large majority. 3 of these 28 times were on the days that the cars were rented to do these trips to Tallahassee. Whether or not that is a coincidence is entirely up to you. After the killers returned from Tallahassee on that first trip, we have a couple text messages of interest. On June 8th, 2014, the defendant indicates he's still working on Dad's birthday present, and Donna indicates, "I know you'll come through." Then on July 6th, we've got Wendi Adelson with a location at or near her parents' place when she texts Dan Markel and confirms he's going to be in town for his own murder. This slide depicts the night before the second trip. We know Katherine Magbanua and the defendant are together that evening at her place. He departs between 12:42 and 1 a.m. And then so after the defendant departs Katherine Magbanua's residence, we've got Katherine Magbanua calling Sigfredo Garcia. So within minutes of the defendant leaving, she calls Garcia. She talks to Garcia several more times into the wee hours of that night, the last one being at 1:56 a.m. And then at 9 a.m. the next morning, Garcia calls the rental car place. Once the Prius is rented, the second trip begins. The Prius is rented at 6:15 p.m. on July 15th, 2014. There are several calls between our parties on the day that the Prius is rented. So we just talked about the night before the Prius was rented. On the day the Prius was rented, we've got these 2 calls, several calls, including these 2 calls from the defendant to his parents' landline. Garcia and Rivera then depart for Tallahassee July 16th about 2 p.m. and arrive in Tallahassee around 1 a.m. Although this trip was only about 36 hours from the time they left Miami to the time they returned, there were 12 phone events between the defendant and Katherine Magbanua during that time, and there were 4 phone events between the defendant and Donna Adelson during that time frame, including late into the night on the night before the murder. On July 17th, Magbanua relayed to the shooters that this murder had to be done that day because the victim was scheduled to leave town the next day. And we confirmed that Dan Markel was in fact scheduled to leave for New York City the next morning on July 19th. It's hard to imagine how Luis Rivera could have obtained this information, if not in that pattern that we consistently observe in this case. Defendant to Magbanua, to Garcia, to Rivera, and back the other way. Certainly you're not really to believe that the killers divined this information from the professor's blog. That's not reasonable. Wendi offered that Danny sometimes put his travel information on Facebook, but you learned from Agent Sanford that there was no information about this particular trip on Danny's Facebook, so they didn't get it from there. This is because, as Rivera and Magbanua both told you, this information came in the form of that letter from defendant through Katherine Magbanua. How would these two hitmen even know where to go or who to kill if they hadn't been given any kind of instruction? Katherine Magbanua said she knew the plan was to kill Wendy's ex, but she never knew his full name until after he was killed. She did, however, deliver that envelope that the defendant put in her diaper bag to Sigfredo Garcia. The paper, she knew, contained the instructions for the murder. Defendant advised Katherine Magbanua that she should not touch the envelope or open it, as he had taken precaution to ensure that his prints and DNA would not be on it, that it would be untraceable to him, and she should do the same. She was to deliver the envelope to Garcia, and that's what she did. This is corroborated by Rivera, who says Garcia had a paper with him on the first trip, and it contained a picture of Dan Markel and a printed address. On the day of the murder, we have communications between our parties as listed here, with the red line representing the time of the murder. This flurry of calls between our persons of interest demonstrates the usual call pattern that we're seeing. Donna to the defendant, to Katherine Magbanua, to Garcia, and back. We have Wendi getting a text message on the day of the murder about her TV repair appointment from her mother, Donna Adelson. It indicates that Best Buy is on their way over to help you with the TV sets in your living room. Maybe she didn't remember which TV was broken. At 8:20, on the day of the murder, Wendi texts the defendant, "This is so sweet." That text was deleted. What does it mean? At 9:19 a.m., because it's cheaper than hiring a hitman. Only you guys can assess if you think that might just be a coincidence and nothing more. The Prius is at Premier at 9:16 a.m. The last phone communication between Garcia and Rivera is at 9:16. Afterwards, the phones turn off, consistent with what Rivera told you. We turned our phones off because we knew we were about to commit the murder, and they don't pop back up until, I think, about 12:30. The bus video catches them turning onto Benton Road to do the murder at 10:51 a.m., whereby they pull up right behind Professor Markel in his driveway. Sigfredo Garcia gets out of the Prius, approaches the driver's window, pointed his gun, and fired. Dan Markel raised his arm to protect himself, but it was no use. Professor Markel was executed at close range, whereby Garcia got back in the Prius and Rivera drove them away. Markel was left there to suffer and die. If not for James Geiger, there's no telling how many hours he might have suffered there alone and unaided. He fought for his life for 14 long hours before he finally succumbed to his injuries. The autopsy confirmed that he was shot twice at close range with a .38 caliber revolver, consistent with what Rivera said they brought as the murder weapon. Next, he was stripped, x-rayed, photographed, and dissected. because he had become a piece of evidence. When Garcia and Rivera get back on the road, they're on a second bus video, leaving town at 10:55. That narrows the time of this shooting down to a 4-minute window between 10:51 when they're seen turning on the Benton and 10:55 when they're caught fleeing the scene. And then we've got the 911 call from Mr. Geiger at 11:01 a.m. The first phone call that either Garcia or Rivera make after turning off their phones to do the murder. So first call after that is at 12:30, and it's Garcia to Katherine Magbanua. Magbanua assures them that they'll get their money the next day. This is the same time frame, roughly, that Wendi Adelson was visiting the crime scene. Wendi indicated that she went to turn onto Trescott from Centerville Road, observed a roadblock, and then turned around. But we learned that what she said happened could not have happened. Instead, the roadblock was all the way down here by the blue dot. I've got two blue dots. The one at the top left of the page there is where the roadblock was, that yellow line, 3 to 5 houses down from the scene. Trescott and Centerville is all the way down where the other yellow bar is. Visible from the roadblock that she approached and was observed doing so by Officer Brannon were multiple law enforcement vehicles, marked vehicles. There was crime scene tape up. There was a marked vehicle with an officer stationed at the perimeter. It was visible from that position that there was something going on at her kid's house, the house where they lived with their father. And what did Wendi Adelson do upon encountering this roadblock and observing that the police were present on the street where her kids lived? She turned around and proceeded to the liquor store to pick up her bullet bourbon. And the defendant says, well, this is another coincidence because she was asked to bring it to a party. Well, maybe. But the timing of the purchase and the fact that she went out of her way to go by the crime scene on her way to get the bullet bourbon should raise an eyebrow. But it's what she didn't do that's even more suspicious. She didn't ask Officer Brannon, hey, what's going on? She didn't call Danny. She didn't call the police to make any inquiries, or even the daycare to make sure her kids made it there that morning. Remember, Danny had her kids. She didn't even call the daycare. Meanwhile, our shooters are headed back to Miami. They pop up on an ATM camera at 6:45 p.m. in Pembroke Pines, Florida. And then both of their phones are consistent with being at Rivera's residence as of about 7 p.m. that night. At 8:23 p.m., Katherine Magbanua and the defendant make plans to meet up at his house. At 9 p.m., Donna texts the defendant, outside your house, to which he responds, 10 men. He told you from the witness stand that this text meant that Donna was just passing by his house on her way to Tallahassee and that they weren't meeting up. But Katherine Magbanua testified that when she arrived at defendant's house, the defendant advised her that his parents had just been there and that he thought his mom had physically washed the money, which was damp when Katherine Magbanua received it. Magbanua finds the defendant to be carrying his gun around and in a frantic state. About the time that these two are meeting up at the defendant's house to do the money exchange, Dan Markel is pronounced dead at TMH. So he says he's going to be about 10 minutes out. Here he is, hitting at home at 9:40 p.m. At 9:46, we see Katherine Magbanua, consistent with being at Rivera's residence, and then consistent with heading toward the defendant's residence. She turns her phone off and it stays off for 11 hours. When Magbanua's phone pops back up, it's 9:44 a.m. on Saturday morning, and she's headed back from the defendant's house, or the direction of his house, toward Rivera's residence. That's the money drop location. These phones are consistent with a meeting at 10:30 at Rivera's, which is the time, date, and place that he advised us he received his money from Magbanua. At 12:13 p.m., the defendant reaches out to Magbanua. Defendant, headed to the gym. Are you taking the kids to the beach? It's so nice. Magbanua, it's beautiful. Probably the pool. Defendant, nice, have fun. Ethan must be happy. This is what he's texting Magbanua within hours of her leaving with all the money in his safe. All of the money that he stared at and loved on since he was a child. And he wants to know if she's going to the pool. This might be a good time to remind you that the jury room is not a place to check your common sense. We want you to bring it in there. You have heard two wildly different versions of how this thing went down, and they can't both be right. I mean, somebody's trying to sell you a bill of goods. You were selected with the belief that you would be able to cut through the garbage and make sense of the evidence in this case and render a verdict that speaks the truth. A major problem for the defense theory is the idea that the defendant and Magbanua broke up after the murder, but then grew closer together over the next 2 years as she was collecting his monthly extortion payments. This is one of the more unreasonable parts of the defendant's testimony, or, well, it's definitely in the top 4, along with Latin King extortion payment plans, hitmen that hire themselves to kill someone that their intended future extortion victim hates, and most unreasonable of all is probably that Charlie Adelson, the guy that talks so tough in the hot tub about his unsavory connections, an arrogant man of extraordinary resources, a prize fighter of verbosity, would just lay down and take this in silence. Let's review some of these love texts. We got that one. Then we've got July 22nd. They're talking about the weather. They're talking about prescription shampoo. On October 6th, the defendant says, "I love you. It makes me feel good that you care about me. I'm very lucky to have you as a part of my life." What? Lucky? Lucky. He says, "I love you" again on 2/24/15. According to him, he's now been making payments for 7 months. He's had her on the payroll for 6 months. No Latin Kings have contacted him in any way about collecting his outstanding debt of $195,000. Yet he continues to pay and love on Katherine Magbanua without reservation and without the slightest suspicion that she might be in on this, and without the slightest concern for helping solve the murder of who killed his brother-in-law. Defendant says he believed Katherine Magbanua wasn't taking any of the money even after he put her on the payroll. Checks are going to her because she seemed broke. Defendant's explanation for all the love texts with Katherine Magbanua is that he felt sorry for her. He felt she was in the same position that he was in, being manipulated in the same way that he was. But the fact remains, folks, that she's taking his money. She's connected to the guy that's extorting him. She's connected to the guy that killed his brother-in-law. It defies logic that he would then proceed to grow closer with her. But he has to say that because he can't, there's no other way around these texts. also defies reason based on what we know of this man, that he would take her for her word and just empty his safe into her purse and then keep paying, presumably forever, without asking any questions, talking about it all, or reporting anything to the police. Magbanua began getting checks from Adelson Institute 2 months after Markel's murder, and she continued receiving checks from that time frame up until the bump. The checks stopped happening at the time of the bump, and you should be asking yourself what that means. Why did the checks stop happening? Well, you would reasonably figure they stopped happening because the parties got spooked, because law enforcement, they suspected the bump could be law enforcement. Law enforcement might be getting closer, take her off the payroll. If defendant was being extorted, as he told you on the witness stand, why would the payments stop? Why would the extortionist care if other extortionists had jumped on the bandwagon? Why would the bump impact the defendant's existing obligations to the original Latin Kings? The defendant said he put her on the payroll at Adelson Institute at her request to help her get insurance for her kids, with the understanding that the money was being funneled through her to someone else and she wasn't actually getting any of the proceeds. She was just going to use that paycheck to assist her with getting subsidized housing or insurance, I think it was, for her kids. But you can see from this slide, which is dated June 24th, 2014, that she's texting him about getting on the payroll prior to this alleged first extortion effort. He says no problem at that time. This is between the first and second trips. She's asking to be on the payroll. So the explanation from defendant about why she's on the payroll does not fit with the other evidence in this case. So we've got all this evidence that points to the defendant. The motive points to him. When we follow the money, it leads to him. The Prius eventually leads back to him through these conspirators. And each time we have a big event in this case, we see these call flurries where all the parties are calling each other in that structure that I talked about. It goes from this one to this one to this one. But as the defense points out, these folks had independent relationships with each other that could explain those communication patterns. So without knowing the content, how could we know if they're really talking about the murder or if these call flurries around these key events are just a coincidence? A conspiracy can be shaped like a cluster with everybody talking to everybody. It can be shaped like a wheel with one central hub talking to all the different spokes. Or it can be shaped like a train car, which is what we have here, where one person talks to only the car in front of them and the car behind them. Law enforcement was asking these same questions. How is this conspiracy shaped? How does it work? How does information flow through it? What are different parties' relative roles within the conspiracy? And the wiretap and bump were designed to answer those questions. Did you notice that Donna Adelson, see how the paper's folded in half? She didn't even look at the paper before she put it in her purse. She didn't think this was a process server. She knew exactly what it was the moment this man approached. And then she just goes about her business. Does she give law enforcement this valuable information that could be used to solve the brutal murder of her son-in-law? I mean, this guy that approached her obviously knows something about who killed Dan Markel, right? So surely she went straight to the cops. Nope. Instead, she goes straight to this defendant, who goes straight to Katherine Magbanua, who goes straight to Sigfredo Garcia. In that first call after the bump, Donna says she doesn't want to talk on the phone, but defendant can't leave it alone. He asks, does it involve me or other people? Her answer, well, probably the both of us. Probably both of us. He says, what's that? Probably the two of us. So you probably have a general idea what I'm talking about. He doesn't say, no, I have no general idea what you're talking about. He says, all right. He absolutely does have a general idea what she's talking about. And if they were innocent, as the defendant has claimed, and this was in fact a second extortion attempt, there is not a reason in the world why they wouldn't just say that. I got approached by another one. One came and paid me a visit today. It's happening again. In call B, the defendant asked Donna to take a picture of the bump letter and send it to him, and she refuses. Why? Are the Latin Kings going to see the text? Do you think someone is trying to blackmail you? Maybe, could be, I don't know. No, that's crazy. That's his response, and I'm not adding the emphasis on that syllable. He says it like that. That's crazy. How is it crazy? You're already being extorted by Latin King members. Remember, doctor? It's because he hadn't come up with that part yet. In call C, defendant calls back again to tell Donna not to talk about things in the apartment or any place. Why? Why? The Latin Kings aren't in there. And she doesn't ask why, because it's obvious. She says, oh, obviously. Why? Because they might be under surveillance? Well, who cares if they have nothing to hide? Here we see the first use of code on the wire. People don't talk in code if they've done nothing wrong. People do not talk in code if they haven't done anything wrong. Defendant knows, he knows that fact, and that's why he told you we didn't talk in code on the wire. We spoke carefully. What does that mean? Careful of what? Defendant also told you under oath that he regrets that his mom randomly used the word TV in this call as part of her careful talk. The defendant got Wendi Adelson a TV as a divorce present as a cheaper alternative to hiring a hitman. Dan Markel was killed by a hitman. Then the same TV is Wendy's alibi for the murder, a service appointment that her mother set up for her from South Florida. And then on the wire, Donna says, quote, this TV is going to cost about $5. Does the defendant say, what TV? What are you talking about, since you inserted a random object into this careful talk conversation? No, he doesn't need to ask what TV, because he knows exactly what she's talking about, and he parrots it back. They asked you for $5,000? The defendant has advised you that this TV stuff is a coincidence. Is it a coincidence, or is it obvious they're referring to their conspiracy and this murder? Only you can decide which explanation is credible. The players in this case are smart. They've given a lot of thought to their preparations before this and to their explanations after. We know the seed was planted in early 2013, and it took over 1 year to come to fruition. And they've really thought of almost everything. A clever TV-related alibi for Wendi, a frame job for Lacasse, and they insulated themselves by hiring Katherine Magbanua as a middleman, walling themselves off like those train cars, only communicating with the one in front and the one behind, and having no connection to the one further down the line. It's also important to note that in these first few calls, A, B, and C, that Donna Adelson describes the bump to the defendant, and she says the person that approached her mentioned an ex-girlfriend, but she does not say the name Katie or Katherine. Then, with only this very limited information, defendant calls only one of his many ex-girlfriends, Katherine Magbanua. In call D, defendant tells Magbanua that he thinks that this undercover, the would-be extortionist, said her name. We know this is true. The undercover did say Katie, but Donna had not yet told the defendant that. They only communicated in calls A, B, and C. And the only communication on those calls was that the person mentioned ex-girlfriend. On the wire, the defendant says he just called Katie, Katherine Magbanua, because she was his most recent ex-girlfriend. Well, we know that's not true because there's at least one woman that defendant will admit meets that definition between Magbanua and the bump, and that's Whitney Kick. On the stand, he told you all that all the you might not be the right Katie conversation. There's several mentions of that. Yo, I'm not sure you're the right Katie. I apologize. I'll feel stupid if you're not the right Katie. That was designed to reassure her that he was not setting her up. Once defendant meets with his mother and gets the details and the paper with the undercover's phone number, he meets up with Katherine Magbanua at Dolce Vita. If they had any evidence, we'd have already gone to the airport. Does that sound like an innocent man? Even if they bug your phone, you're still not talking about any of this. Talking about what? The cops would only bug your phone to get information about the murder. And if you don't have any, then there's nothing to not talk about. The cops aren't going to be doing a wiretap to investigate him getting extorted, which he hasn't even reported to law enforcement. So, not talk about what? Defendant discusses how he's going to start arming himself and is prepared to shoot. He told you under oath from the stand that he was being threatened and extorted by gang members for 2 years at the time that this recording was made. And now he's just starting to think about carrying a gun? Does this sound like a man that's been living in fear for 2 years? Does this sound like a guy who lays down and takes his lumps without question when threatened? Someone comes up to me asking for money in my house? He says that. Lines 23 and 24 on the top there. He says this as if it's a preposterous proposition that somebody would just walk into his house and demand money. But isn't that what happened to you? How is that preposterous? But wait, what changed? On the next page he says, yeah, and when guess what? When the fucking police show up and there's a doctor, there's an oral surgeon standing there with a dead gang member in his fucking driveway, they're not going to come down too hard on me. This is the same man who took the witness stand and swore under oath that he was a victim in this case and that he had been too paralyzed by fear of gang members to come forward and report his victimization. Dr. Adelson on this recording is the real Dr. Adelson. On the stand, he was so controlled, so knowledgeable about his case, so practiced. But there is no way to explain away his statements on this recording. When the bump happens, you get to observe this defendant in action in his role as fixer or problem solver. He's working those phones, trying to get Katie to investigate the bump and find out if it's legitimate or not, and also trying to reassure Donna that it's just the cops fishing and it's nothing to worry about. The bump is an actual recorded example of how this defendant acts when he is threatened by a purported extortionist. And how he acts is the complete opposite of how he's telling y'all he acted in the first extortion. Number one, he does not stay quiet about the bump. He talks about it a lot. There are multiple calls with Donna and Katie discussing the bump and what the next step should be. Two, he takes action. There are multiple in-person meetings with his mom and with Katie and eventually with his dad too about the bump and what to do about it. Three, he investigates the bump. He asks questions. He enlists Magbanua to find out who this is. He talks a lot about his concerns that this will not be just a one-time payment but could turn into some ongoing problem. And four, he doesn't take it lying down. He threatens Nazi shit if these people think they can threaten his family and get away with it. He suggests that the problem might require an additional murder. Quote, if he can't do it, I'll find someone else that can. Number five, he's suspicious. He does not blindly accept the representations of this purported blackmailer that approached his mother. It's clear from the Dolce meeting that he doesn't fully trust Katie. He certainly doesn't trust this purported blackmailer that bumped into his mom. The person that represented themselves, the person that approached his mom represented himself as a Latin King gang member, right? I'm a brother of this guy that I met in Broward or whatever. And he's demanding money from her. Yet, the defendant does not take his word for it that he's a gang member. He's not so in fear for his mother's life that he opens the safe and gets $5 grand more out and gives it to Katie. A pittance compared to the amount he's telling you he handed out to the first layer of extortion. Number six, he doesn't pay. He doesn't bring the $5 grand to Dolce and give it to Katie and say, go pay it. Because that's what I do when I'm threatened, I pay. He doesn't pay, he doesn't ever pay. And it's only $5 grand. Instead, he analyzes and thinks through and talks about every possible scenario. Defendant says it's one of two things, or one of two scenarios. One being the cops, two being someone actually trying to blackmail his family about this murder. According to him now, he's been blackmailed for 2 years. And he's talking to Katherine Magbanua. He's talking to the person that's been collecting his money all those months. But at no point does he acknowledge the first extortion in the Dolce Vita meeting. Why not? Oh, because she asked me not to talk about it. Well, times have changed. There's a second extortion effort now, and they're approaching my mother. You think I'm not going to mention the first extortion? Your people have been running their mouths, and now they've tracked down my mother. You need to go get this under control. Nothing like that. Next in the Dolce recording, defendant begins to explain how to prove a crime. The police have to put the person at the scene, not just in the car. He's reassuring her that even if we, law enforcement, can tie her or the shooters to the Prius, that we'll never be able to charge them. Because they didn't come to Tallahassee, they didn't shoot anyone, they didn't do anything wrong, and therefore they can't be held accountable. But that is not the law as the judge has instructed you. Everyone who wanted this done and did some act toward accomplishing it is guilty as the one that pulled the trigger. He's also telling her that even if Rivera has run his mouth to this would-be extortionist, his word alone that, hey, if he goes to the cops and says, starts singing and says, hey, Rivera told me he did this murder, that's not going to be enough. Basically, he didn't use the word hearsay, but that's not going to be enough to proceed on an arrest in this case. This person knows information, so Katie, they'll be back. Whoever it is knows information. Information about what? You had nothing to do with it. Remember that, doctor? You've been extorted and that hasn't been reported. What information do they have? You mean information that could be used to solve the murder of your former brother-in-law? If so, why wouldn't you want those people to go to the cops? Why wouldn't you want them to come forward with that information? Then the guilty parties will be held accountable. Your extortionist will be jailed without you having to do or risk anything. Next, defendant talks about what will happen if the would-be extortionist, the undercover, is picked up by law enforcement. Next thing you know, this person is singing. Other people start singing. As soon as they have him, he starts calling your name out, and then there's going to be police at your door and at my door. If you're innocent of this murder, why are you worried about the extortionist telling law enforcement whatever it is he knows about the murder of Dan Markel? Defendant says he wants to pay the money. Oh, got ahead of myself. He wants to pay the money, but he's explaining to her the problem with paying is that people might keep coming back or tell their friends who will jump on board as well. He's explaining to her the problems with paying a potential extortionist. What he doesn't say, which is what you would expect if he'd been getting extorted for 2 years, is Garcia, or whoever you've been giving my money to, has obviously been running their mouths, and now they are messing with my mother. Next, he gives instructions. Say my friends have no idea what you're talking about. And frankly, I don't know what you're talking about, but the name sounds familiar of who's incarcerated. So I'm going to give you something as charity to help the less fortunate. But do not contact these people again or they're going to the police. The whole time you're talking, just say, I don't know what's going on. Only use the words help and charity. This isn't the guy described in this first extortion who just rolled over when threatened. He's in control. He's giving the orders. He's giving instructions. Why would you have to give instructions to a blackmailer about how to handle a blackmailer? Next, the defendant says, now he's fucking with his wife and he's fucking with him, and you fuck with the king himself, you better kill him because he's going to be a big problem. And he knows who you are. If he can't do it, I'll have someone else do it. Defendant testified that this means the only way to stop Garcia is to kill him. He's not talking about killing him. He's just saying he's a really bad dude, and that's the only way to kill him. The evidence shows that he's saying if Garcia can't handle the undercover, he'll get somebody else to do it. Then he says, and so help me God, if they fuck with my family, it's gonna be fucking Nazi shit, because this will be done. I mean, Katie, I don't care what I spend, okay? I swear to God. Defendant and I went back and forth on the stand about what Nazi shit might include, and I think we ultimately agreed that that would be killing. And then he says, I don't care what I have to spend. If you're struggling to figure out who this man is, that's a good clue right there. He's going to buy a solution to this problem exactly how he paid for a solution to the problem of Danny Markel. Here he wants to know if Garcia has any bad feelings toward him, meaning, is Garcia willing to look into this and handle this for me? Or does he still hate me because I used to date you? If defendant had really been getting extorted all along, surely he'd say something like, I've been paying all this money, I've been compliant with everything, can you get him to look into this and figure this out? Katie, I'll go to the moon and back for you. Why? Because she did something big for him, and he's going to be indebted to her for the rest of his life. Not because he feels sorry for her, not because she's his protector. He's the protector. He'll go to the moon and back for her because they're neck deep in this conspiracy together. Somebody messes with her, they mess with him. Somebody messes with him, they're messing with her. It's the same thing. Here he's demonstrating an understanding of a rational understanding of how blackmail works. His example is that you could blackmail someone that's cheating on their wife, meaning you blackmail someone that you have dirt on. You don't go kill somebody and then go up to an innocent person and say, I killed your brother-in-law, give me money. At the end of the conversation, defendant says, you know who this is coming from? Inside. And then I don't have a slide for this, but he goes on to talk about what he will do for her. I don't have to sit here and tell you what I would do. I show you what I could do. You know what I'm saying? You know how I am. I look for things to do. You don't ask me for shit. Didn't she ask you for $138,000 and then a payment plan and then another $195,000? You don't ask me for shit. I look for things to do for you. Is that a statement that would be made to his blackmailer, or at least the woman that's taking the money to the blackmailers? These are just a selection of the incriminating quotes on this Dolce Vita recording, and I know it's a struggle to listen to it. You will have the recording, not the transcripts, but you'll have all the audios. The transcripts are just demonstratives, they don't go back. But you can kind of hunker down and listen as much as you can to get what you can out of that Dolce recording, because it is full of gems, and you can probably think of 10 more arguments than the ones I've just tortured you with today. In the initial recordings, the defendant and Magbanua seem to be kind of dancing around the issue, right? Nobody ever speaks directly. He can't know for sure at this point that she's not involved in the extortion effort or possibly wearing a wire, and she can't know for sure that he's not wearing a wire. So they're both just feeling each other out in the first several interactions after the bump. But those are the best stuff before they start to figure out, okay, we really think this is law enforcement. After the meeting with Magbanua, defendant calls Donna and tells her he had coffee with a friend and gave her some good relationship advice. Now remember, he's not talking in code. He assures Donna repeatedly that it's being handled and there's nothing to worry about. Then we hear in call H, the call where Magbanua calls Garcia and he's really angry. And she needs him to call that number to figure out who this is and to deal with it. Ultimately, Garcia says he will take care of the problem. The less she knows, the better. And then he tells her to stop talking about it on the phone and hangs up. Then we go to this. That's that. Then we've got the real struggle over the phone number. The point of this is that this number was handed to Donna. The number goes from Donna to Charlie, to Katie, and now to Garcia. Here in call J, we hear the reference to investment as code for the $5,000 extortion payment. A good investment would be someone who really does know something, not somebody that's just fishing, and will agree that $5,000 is going to handle it. You're going to go away, you're going to be silent about whatever you know, $5,000 is going to do it. A bad investment would be someone who's just read the papers and decided, hey, I'm going to try this, a law enforcement officer, or somebody that's going to take the $5,000 and then just keep coming back for more and more and more and more, and it'll be a continuous problem. This is a composite slide of all the places in the recordings that are in evidence where the parties express concerns about the details that the undercover had. It's getting too detailed. He's coming up with a lot of fucking details, etc. It's obvious they're analyzing the legitimacy of the undercover and assessing how much of a threat he is based on the quantity and the quality of the details that he has about the killing of Dan Markel. Then you've got more property and listing, code talk, more concern that the blackmailer might try to increase the amount. Here's a composite slide illustrating all the different calls where the defendant expresses concern that if he pays, that might not be the end of it. And the reason why I think this is so important is because you've been paying for 2 years. Why are you analyzing how blackmail goes or might go so much? You're supposedly an expert in it. Here, defendant gets stern with Katherine Magbanua, telling her to find out who the F it is and stop playing their games. Again, for a guy that's living in mortal fear of Latin King gang members, he's pretty confident. He's pretty in control. Recall that in this one call, she basically says, I can't, she's really furious in this call. She's like, I can't do all this code anymore. I can't talk in code. Remember, defendant told you he didn't talk in code on the wire. So she breaks character here in this call, BB. Then defendant later says to her the quote I already gave you about how they're in this together. They're one and the same. And I couldn't agree more with that statement. This slide is a composite of all the places where defendant says if he had information about the murder, he would collect the reward money. First of all, whichever side of this case, whichever theory you're finding credible, both sides agree that the defendant knew the whole time who killed Dan Markel, or close to the whole time. So definitely could have gone and gotten the reward money, although it's hard to imagine he would collect reward money for information about the death of his own loved one. Defendant claims he doesn't go to the police, period. And he offers an example of I had a jet ski stolen and I didn't go to the police. Well, maybe the insurance was worth more than the trouble of the cops. I don't know. But he has gone to the police before. There was evidence of that. And the evidence shows that when somebody messes with him, he comes at them with everything he has. On the lawsuit with Ryan Fitzpatrick, the incident with his child's mother, incident with an old roommate, incident with a former female employee, some of those included reports to law enforcement. Some of them included use of other resources. In the last case with the female employee, he sent a letter that said, he accused her of trying to shake him down. So she's trying to extort him. And it states that he would never pay her a dime. In fact, I'm going to get attorney's fees. He's a guy with considerable resources, and he's not a shrinking violet. He is not afraid to use those resources to his advantage. If some street thug was trying to push him around, do you think he'd lay down and take that without doing one thing about it? This slide is a composite of some of the occasions defendant mentions the option of going to the police. And these quotes are specifically in reference to him saying, if you're threatened, you go to the police. If you're threatened, you go to the police. And he has done that before, but he did not go to the police in this case. He didn't go to the police in 2014, not out of fear, as he would have you believe, but because he did this crime. He believed he had gotten away with this crime. He didn't go in 2015 because he was busy that year having the best year of his life. Financially, got in a serious relationship with a new girl, June Mchinda, cruised the intercoastal in his boat. This dude had solved the problem. Everyone was happy. Wendi and the boys were back in South Florida where they belonged. Mom was happy. He was making money hand over fist. June described the beginning of their relationship. June Mchinda described the beginning of her relationship with this defendant in October of 15 as a fairy tale. He is not sweating anything, folks. And that continued until the time of the bump in this case in April 2016, whereby the defendant became agitated, angry, and anxious. This was before the report concerning him was leaked. At the time of the bump, his behavior changed noticeably. June noticed it, and Ryan Fitzpatrick noticed it as well. He was erratic. Now, why on earth would he be more stressed out after his extortionists were arrested? He seemed perfectly fine to these witnesses when he would have you believe he was in fear for his life. And then he further told you that he was more nervous after the arrest because he feared he'd be falsely arrested. Why? You didn't do anything wrong, you're not gonna get arrested. Now, yeah, after the report gets leaked, okay, but why are you so nervous before that? Or were you a hot mess because you knew that we were getting closer? Here's Katherine Magbanua and the defendant discussing if the undercover could be someone who's trying to be an informant. An informant for what, if not the death of Dan Markel? He's not going to be an informant on the defendant getting extorted, a crime he has not reported. Here they're talking about whether the undercover is getting his information from the inside or the outside. The inside meaning someone within the murder conspiracy, someone on that board, or the outside, somebody that one of those people told. Magbanua says it can only be one of two, apparently. If somebody's that desperate, not from the inside, because there's too much from the inside that the person knows from the outside, so they won't risk it. That's why I know for a fact it's not from the inside. And Adelson says it's somebody not from the first layer, but probably the second layer. Yeah, and they just made a big mistake, she says. As the wire goes on and the defendant proceeds to continue to analyze the additional bump efforts that law enforcement makes, that text message, the letter, the call to the Adelson Institute, he becomes increasingly confident that this would-be extortionist is an undercover agent. And then after listening to Donna's call to the undercover, he is completely sure of that. And you have never seen anybody so elated to be under investigation by the FBI for first-degree murder. Consider this in light of defendant's assertions that he was acting strangely after the bump because he was worried about being falsely arrested. To the contrary, he doesn't seem worried at all. He seems thrilled. I think he says it's fantastic in one of these calls. I want to turn briefly to your jury instructions. The defendant is charged with conspiracy to commit murder, solicitation to commit murder, and first-degree murder. Why all three? Because the defendant didn't just ask Katherine Magbanua to do this and promise her money. He didn't just set a plan of action in place toward doing it. It got done. It got done, and that's what makes it a murder. That's the difference between just conspiring. You didn't just conspire, it got done. This is the difference between just soliciting or just conspiring and being a principal to first-degree murder. To prove the crime of first-degree murder, I must prove to you that this was premeditated. Premeditation is defined as killing after consciously intending to do so. This murder, consciously deciding to do so. All right, so this murder was in the works for over a year. It began with the failed relocation efforts. When defendant first looked into hiring a hitman, it took root when he enlisted Katherine Magbanua, and she thereby brought in Garcia and Rivera to do the killing. The planning that went into the killing was extensive, spanning over a year, and it included the solicitation of Magbanua to find someone to do the murder, the preparation of that letter and that envelope that were placed in Katherine Magbanua's diaper bag, free of DNA or prints containing the directions for a murder that was delivered to the hired gun, Sigfredo Garcia. 3, the payments that were made in advance for renting the vehicles in the hotel room, the expenses associated with those trips. That was part of the planning. 4, the scouting and stalking of Professor Markel that we learned went on in both trips. And 5, the pressure that defendant applied to Katherine Magbanua after that first attempt failed. Get it done, get it done, get it done. 6, of course, is the payment itself. He paid for it. All the planning, all the meetings, all the precautions were coming to fruition when that hired gun fired those 2 shots that devastated so many lives on July 18th, 2014. When you think about how this case was proven, we started at a single point, the crime scene, and we went in 2 totally different directions. We chased the Prius, and we chased the motive, the bad blood of the in-laws. And the investigation could have stalled if either of these leads had resulted in a dead end. But all the little breadcrumbs led to the same place. The Prius led to Garcia and Rivera, which led to Magbanua. The bad blood and the divorce led to the Adelson family. The wire confirmed the defendant's specific involvement, not just some Adelson, that Adelson. Then Rivera and eventually Magbanua confirmed his involvement as well. I want to spend a moment talking about the principal instruction. We talked about this in jury selection. The defendant didn't pull the trigger, but that doesn't mean he isn't just as responsible as the person who did. Without every player in this conspiracy, the murder doesn't get done. In your jury instructions, it says there are 2 ways to prove defendant's guilt under the law of principles. If he intended that the murder be done and he did some act, preparing the paper, procuring Magbanua, or said some word, get it done, get it done, get it done, that caused or helped another to commit the crime, then he is guilty of first-degree murder. Or, 2 ways you can find it. Or, if he intended the murder to be done, and he made or promised payment in exchange for the murder, and the crime was committed by another person, he's guilty of first-degree murder. My burden today is to prove to you this case beyond a reasonable doubt. The jury instructions tell you that a reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. So when you're stuck back there deliberating, ask yourself, what is reasonable? When you're weighing a piece of evidence and deciding, like, is this a doubt or not? Is it reasonable? Does it fit with the other evidence in the case? If you find yourself saying, what if, or a fellow juror is saying, what if, without evidence to support whatever it is that comes after the what if, that's speculation. Remind your fellow jurors to get back on track. And that cannot be a reasonable doubt if it's speculation. My burden is to prove the elements of the listed offenses. Nothing more. If you have a question that I have failed to prove the answer to, but it's not one of these elements of the crime that the judge has given you, that is not a reasonable doubt. I'm concerned that you'll get back there and think, well, he didn't pull the trigger, so let's just do conspiracy and solicitation. You guys have worked too hard to render a compromised verdict at this point. I trust that each of you will follow the law and your oath to render a wise and legal verdict in this case. This defendant is guilty of first-degree murder under the principal theory, if ever anyone has been. So the efforts to distract you from this case and what it's really about, including these clear links in this conspiracy and all the evidence that establishes them, the text, the calls, the records, the testimony of Rivera, the testimony of Magbanua, all those things together. The wiretap, the phone calls, the iCloud messages, and the absence of any other reasonable explanation should all lead you to one conclusion. This is the puzzle. This is the puzzle. The image is clear. When I confronted Rivera with the defense theory that he and Garcia acted alone to kill Markel and then extorted money out of the dentist through Magbanua, he found it laughable. I wrote down his quote, that's a good one. It came out in this trial that in Garcia's trial, Rivera was portrayed as the sole killer, the bad guy. He conspired directly with Charlie Adelson, according to Garcia, to commit the murder through WhatsApp or some kind of way. Garcia's lawyers said this was all done without the knowledge and participation of Garcia. Then we learned in Magbanua's trial, Garcia supposedly conspired directly.
Objection, Your Honor.
Roach. You're to rely on your memories of what took place during the testimony and evidence. You may continue with your argument.
Now, here we are in the trial of Charlie Adelson, and the truth has been revealed. Once again, the state got this almost right. That's what you heard in the opening from Mr. Rashbaum. We understandably thought that his client, Mr. Adelson, was the hirer of this murder, but there's a twist. Nothing is as it appears to be. The defendant is really the second victim in all of this. Per his theory, the killers drove to Miami twice to kill someone they'd never met and had no motive to kill, in hopes that Charlie Adelson would, one, not report them for murder, and two, would instead agree to give them large amounts of cash at that time and on a payment plan over the next, years. Other than failing the smell test, there are a few specific problems with the defense theory. One, how would the killers have known where to go to kill Markel? How would they know who to kill? How could the killers have known that Dan Markel was scheduled to leave town the day after the murder? Three, possibly the biggest problem, the theory itself makes no sense. Were they just hoping that this would work? We're going to go all the way up there and kill somebody, and maybe they'll give us some money. If they were going to confess to doing the murder to Charlie Adelson in order to try to get money, why not just put a gun to his head and take his money? Why not just rob and or extort him with the threat of death by Latin King? That would save you the trip and the murder rap. Their jigsaw puzzle theory is just a pile of pieces that don't fit together. Each explanation is carefully designed to explain one piece of evidence. But how many different explanations can you string together before it's no longer reasonable? How many coincidences can there be before it's no longer a coincidence? This defendant is not a victim. He's a criminal. He's wealthy, he's smart, and he's successful. But he's a wealthy, smart, successful murderer. My work is almost done here, and yours is just beginning. I trust that each of you will do your best to render a wise and legal verdict in this case. A verdict that speaks the truth. A just verdict. And that is a verdict of guilty as charged. Thank you.
The defense prepared to do its closing.
Yes, Your Honor. Maybe you just have a couple moments to set up. Might be
Okay.
good for break.
You may set up.
Please.
Right while they're setting up, the bailiff will escort you back into the jury room.
Good. Maybe you use the restroom as well.
Go ahead. Okay,
She didn't have nobody to bring it to her, so she made me the last.
gotcha.
Check on that.
Everyone can be seated.
You gotta stop. I just want to discussion.
Good morning. Everyone can be seated. Mr. Rauschbaum, you may give the defense's closing.
Thank you, Your Honor. May it please the court, counsel. Good morning. Good morning. As we discussed in jury selection, Charles Adelson is presumed to be innocent. To overcome that presumption of innocence, the state has the heavy burden of proving beyond a reasonable doubt that Charlie committed the crime that they say he committed. We did not have to present any evidence whatsoever. That's how our system works. We did not need to prove his innocence. As you go through the trial, you were told that you needed to evaluate the evidence through a lens of innocence, a presumption of innocence. Now, I think we did prove his innocence in this trial, but that isn't the standard. That's not what you go back there and deliberate. What you see in this trial is a mountain of reasonable doubt that arises from the evidence itself, from the conflict in the evidence, and from the lack of evidence. The state's first question to Mr. Adelson when he was on the stand was something called Occam's razor. Their first question was referring to their belief that the simple answer is the preferred answer. You might recall them asking that question, the very first question they asked Charlie. Occam's razor, that proposition that the simple answer is the preferred answer, is the exact opposite of what our criminal justice system is about. See, Occam's razor is a guess. We don't guess in this country. We don't assume people to be guilty. We presume them to be innocent. And sometimes the simple answer is the wrong answer. Sometimes things aren't so simple. And that's what we have in this case. I talked to you in opening about puzzle pieces. I talked to you in opening about how puzzle pieces wouldn't fit. And that's exactly what you saw repeatedly in this case. Just one of those puzzle pieces is enough for reasonable doubt. But here we have a mountain of them. And let's talk about them briefly. Government Exhibit 59. This is their conspiracy chart. The first puzzle piece that doesn't fit is motive. See, Charlie Adelson didn't have a motive to upend his wife. Charlie Adelson had a good life. His business was booming. He was supportive of his sister, but he didn't wake up in the morning thinking about Professor Markel. He didn't go to bed at night thinking about the problems his sister was having. He was living his life. Now, was it a bitter divorce? Absolutely. But through all of those crazy emails, are there any examples of any violence? None. Those emails, we spent about 10 minutes hearing about them this morning. Not Charlie's ideas. By the way, those emails weren't even done. You heard from Wendi Adelson. She never offered any of those things to Professor Markel. She never threatened him with any of those things. crazy ideas? Yes. An upset mother? Yes. Pushing each other's buttons? Yes. But ladies and gentlemen, even the $1 million offer you heard, lawyers were consulted to make sure it was legal. A far cry from a murder. Their relocation motive. Relocation was denied a year before the murder. And by the way, Wendi Adelson and her 2 boys moving to South Florida would have no impact on Charlie Adelson. Would he be happy that they were there? Sure. Would it change his life? No. Now, you may wonder, why did we spend so much time on cross proving Wendi Adelson's innocence? The reason being is because on their exhibit, take a look who is in their conspiracy. They circled her for you in their opening cross. See, they were guessing about Wendi just like they're guessing about Charlie. What the evidence showed is that Wendi wanted to leave South Florida. But when it was denied in the summer of 2013, she made a life here in Tallahassee. What the evidence showed, and remember, I tried to get in email after email after email, and they fought me on it. Ask yourself why. Ask yourself what they were afraid for you to see. You saw that she made appointments after the time of the murder. She made them before. You saw she made plane tickets from Tallahassee to other places in the fall and winter. You saw that she got a new divorce lawyer. You saw that she was making play dates. And significantly, you saw that the entire family was making plans to come up here and see her celebrated for her book at FSU with incoming students. Why is that significant? Because their theory, their simple theory, is that she was part of a murder. It's a puzzle piece that does not fit. And we're going to talk about her trip down Trescott on the 18th, because that's a puzzle piece that they keep on trying to pound and doesn't fit, but we'll do that a little later. The next puzzle piece that doesn't fit. Who had the kids? See, one thing that the state and the defense can agree on is that the Adelsons love these 2 boys. But they would have you believe that they hired hitmen twice. And both times, who had custody of the kids? They would take a risk that these boys would be injured, killed. Does that make any sense? The June attempt. Remember, Wendi and Danny shared the kids 50-50. The June attempt, we learned from their witness, Luis Rivera, Danny had custody of the kids. And we learned that he wouldn't do the murder because the kids were there. The July attempt, they show you a text message about Professor Markel being in town. And they show you a text message where Wendy's asking for the boys on the 16th. The murder's done on the 18th. Who has custody of the kids? Professor Markel. It doesn't make sense. There is no chance if these people were behind the murder, they would take any risk that those boys would be in the crosshairs. Use your common sense. It's a puzzle piece that they cannot explain. And you know what else doesn't make sense? Is their alibi argument. So they make a big argument about this Best Buy repairman coming that morning, how it was set up for an alibi. The argument, by the way, makes absolutely no sense, because then they argue that Wendi purposefully went down the street of where she was supposed to get an alibi from. But let me ask you this question. Again, use your common sense. If the Adelsons and Charlie wanted to set up an alibi for not only Wendi, but themselves, why not do the murder on July 5th when each and every one of them is at a birthday party for their father in South Florida? Wouldn't that have been a better alibi? They didn't do that because they're not behind the murder. They didn't know it was going to happen. They have nothing to do with it. It's a puzzle piece that doesn't make sense. It's reasonable doubt. Sigfredo threatened Charlie. Now the state has them as co-conspirators. The testimony is clear. Sigfredo Garcia hated Charlie Adelson. The testimony is clear from their own witnesses that Sigfredo Garcia wanted to kill Charlie Adelson. In fact, you hear that on March 11th, 2014, just 8.5 weeks before the first attempt, you hear that Rivera, that Sigfredo was stalking Charlie, and he wanted to run him over with his car. He wanted to kill him. He's going to do that 8 weeks before he does a murder for him? Makes no sense. But it gets worse. You heard testimony in this courtroom from repeated witnesses, both law enforcement and otherwise, that on July 1st, just 17 days before the murder, Sigfredo Garcia tried to run Charlie off the road, threatened him, left a threatening voicemail that he was going to kill him, left it with his dad, but thought he was leaving it for Charlie. It's just 17 days before the state wants you to believe he went and did a hit for him. It doesn't make any sense. It's a puzzle piece that doesn't fit. Now they'll come up here in rebuttal and they'll probably say something like, Sigfredo didn't know what he was doing, Katie was siloing him of information. Ask yourselves if that makes any sense. Ask yourself if after the first attempt he doesn't know exactly who he's killing. It's reasonable doubt, ladies and gentlemen. It's a puzzle piece that they cannot explain. The hitman joke. We learned in this trial that Charlie repeatedly made this off-color joke. And let me say something aside. You don't have to like Charlie Adelson. There are plenty of reasons not to like him. that doesn't make him a murderer. Now, this hitman joke, we learned that Charlie made it with people he hardly knew, that he made it repeatedly. We learned from their own witness that at a March 11th dinner, this is Jeff Lacoste, when he first met Charlie, Charlie made the joke. Ask yourselves, does it make any sense for a guy who is about to do a hit, about to murder someone, to go around town and advertise it? Doesn't fit. Reasonable doubt. Ask yourselves, does it make more sense for Katherine Magbanua, a professional liar and con artist, to hear the joke, to hear the $1 million offer, and start to get ideas? They want to call it coincidences. It's not a coincidence. Criminals do not advertise what they are about to do. That makes no sense. Reasonable doubt. Puzzle pieces that don't fit. Payment evidence. Miss Kappelman mocked in her cross of Charlie that this was a murder by layaway, meaning that doesn't make any sense. We agree with her. It doesn't make any sense. Murders for hire are not done by layaway. But you know what is done by layaway? Extortions. See, we learned in this trial that Katherine Magbanua got paid every month. She denied it. Their own witnesses proved it. We learned that she got paid $3,000 a month, $2,000 in cash and $1,000 in checks from the Adelson Institute. By the way, if Charlie's part of a murder, they're telling you how smart he is. Does it make any sense that he would create a paper trail of checks from his business to pay for the murder? It makes no sense. But aside from that, you heard from Special Agent Sanford. He has done around a dozen murder for hires. Never a payment over time. He's seen extortions like that, but never someone getting paid over time. The money drop was the next day. You heard about that. Ask yourself, if this was a murder for hire, why was payment not made before? See, the state gave you examples of days before the first attempt and days before the murder, where Charlie Adelson was with Katherine Magbanua. If it's a murder for hire, why didn't he pay her before? You heard on the night of the murder and the night of the extortion, she had to go run around town to find a babysitter for her kids. If it was planned, if Charlie was behind it, why would she not have it planned out? Why would she need a babysitter at all if it was a murder for hire? If it's a murder for hire, how much time does it take to go pick up money? Go to the house, get the bag of money, and leave. See, the thing is, she didn't know how much time it was going to take. And you know why she didn't know how much time it was going to take? Because she didn't know how he was going to react. It wasn't just a pickup of the money on July 18th. It was a setup of an extortion. Now, we're going to get more into the extortion, but it's amazing to me that the state still doesn't understand what happened. And I wonder if they don't understand or they're trying to confuse you. So let me make this crystal clear now, and we'll get back to it later. On the night of the 18th, Charlie Adelson had no idea about anything about the Latin Kings. He had no knowledge of the Latin Kings. He doesn't find out anything about the Latin Kings until he's in the car with Katherine Magbanua moments before he goes into Dolce Vita. On the night of the 18th, what he's told is that Katherine Magbanua said she spoke too much and that a friend of hers had done this. Nothing about any Latin Kings. The payment structure makes no sense. The whole purpose of a murder for hire is to hire someone who you are not associated with, who you are not tied to. But yet, they would have you believe that Charlie would give them checks, would continue to text message with them, would continue to give them gifts because he was tied to a murder for hire. It shows just the opposite. It shows it's an extortion. Reasonable doubt. Katie's lies. Let me first start by apologizing if any of you were offended by the tone of my voice during my cross of Katherine Magbanua. See, the thing is, I think you all know me pretty well by now, I'm passionate. And I believe in the system. And the one thing I hate is when someone comes in this courtroom and lies. I hate even more when a murderer comes in this courtroom and lies. What we know is that the state called Katherine Magbanua. Talk about desperation in trying to prove their case beyond a reasonable doubt. They called a woman who lied under oath in her first trial. They called a woman who lied under oath in her second trial. They called a woman who tried to get Sigfredo Garcia to lie for her in her second trial. But worse, they called a woman who just a year ago lied during her proffers. She denied it. And by the way, they didn't question her on it. But you heard from their own witnesses, including Special Agent Sanford, that he walked out of the room. And he walked out of the room not the first 10 minutes. He walked out of the room over 3 hours after she started speaking. Because as he put it, what she was saying made no sense. And they're going to have you base this man's freedom on her words? And why did she lie? Because it's her only way out. But her lying didn't stop there. She lied to you. We caught her in lies. She said she didn't get paid overtime. We know she got paid overtime. She said she didn't know when the murder happened, when the plan changed to a murder, and that the plan was to murder Professor Markel. You've heard the wires. We see her lying to her co-conspirator, according to them, Charlie Adelson, on the wires themselves. We see her saying repeatedly to him that she has called the number hundreds of times, that it's a non-working number, that the number just rings, that they left a voicemail. All of those are lies. By the way, you know who she doesn't lie to? Sigfredo Garcia. You know who else she lied to? Luis Rivera. We heard that. She lied to him about the purpose of the trip. She lied to him about the lady being on the street. She told Luis that Wendi was on the street the day before the murder with her kids. Now, you may remember the judge read a stipulation in, which both sides agree on, that shows that Wendi could not be on the street with the kids. Luis Rivera didn't lie. She lied to him. She lied to him about the amount of money they got. She told him it was $100,000 when it was $138,000. And she never told him that she was getting paid every month. Remember, Rivera wanted to do a robbery. Ms. Kappelman comes up here in her closing, and she says, why didn't they just do a robbery? Wouldn't that have been easier? Remember, Rivera brought up that very point. And what is he told by Sigfredo Garcia? It can't be a robbery. Katie says we have to do it this way. Ask yourself why. The bottom line is, Charlie Adelson was conned. On the night of the 18th, he was scared. He didn't think she was part of it. He thought she was protecting him. That's why he thought that the money didn't go up every month. That's why he thought he wasn't getting visited by any bad guys. And that made him closer to her over time. Reasonable doubt, a puzzle piece doesn't fit. Immunity. She was offered a get out of jail free card, and she didn't take it. She was offered it before her first trial. Now, she had an explanation for that. I didn't want to turn on my husband. But what about after he was convicted and his appeals were over? Remember, her first trial was in 19. Her second trial was in 2022. See, she couldn't take the immunity offer because when you take the immunity offer, you have to tell the truth. And if you're caught telling a lie, you not only lose immunity, but you've now confessed. You now have no defense. She knew she extorted Charlie. She knew she tricked him. She knew he wasn't part of the murder, and that's why she never took the immunity deal. Reasonable doubt. Puzzle pieces that no matter how hard you try to hammer them in, don't fit. And let me ask you a question. Ask yourself why, when the state called her as a witness, they didn't ask her one question about the wires. Go back and look at your notes. Not one question about what was said and meant at Dolce Vita. Not one question of what they talked about in the car before Dolce Vita. And then Charlie Adelson takes the stand. And they have an opportunity to rebut him. They have an opportunity to call her back to the stand and say, you're not going to believe this crazy, unreasonable story that Charlie just wove. But they don't call her back to the stand. They don't ask her any of those questions because they don't trust her. Because they know that she can't answer those questions. Because the truth is, they have doubt. You heard it. They have doubt. That's why it took them 6 years after her arrest to even charge Charlie Adelson. Ask yourselves, why were they so afraid to ask her any of those questions? Security cameras. Now, let me be clear. In closing, Ms. Kappelman said that no one testified that Charlie's demeanor changed in 2014. No one was asked about that. He doesn't meet June Mchinda until 2015. But what we do know is his behavior did change. What we know from evidence in the record is that he started sleeping with a gun. What we know from evidence in the record is that he invested in camera equipment for his house and for the office. Now, the state comes up here and they say, well, there's this email or text message from months earlier where he's talking about putting in camera equipment. True. Guess what he didn't do months earlier? He didn't put in camera equipment. But guess what he does just weeks after he's extorted? Just weeks after Professor Markel is brutally murdered in broad daylight in his driveway. He puts in camera equipment. If he's a co-conspirator, who's he afraid of? According to them, he's the guy behind it. The camera equipment is to protect himself against himself? Reasonable doubt. The wires support what happened on the night of the 18th. They support that he was extorted. Now, I'll first talk about State's Exhibit 130. You'll remember this when I talk about it. It's 21 months after the murder and the extortion. It's before the bump. It's one of these calls about Dave. And it's very interesting and scary what happened in this trial on this call. State plays 18 minutes of the call, and then they cut it off. They ask the witness how important the call is because it's before the bump. Meaning there's no reason whatsoever that anyone is thinking that they're being listened to. 21 months after the murder, 21 months after the extortion. And at 20 minutes and 40 seconds in the call, 2 minutes after they cut it off, you hear what Charlie Adelson thought about Professor Markel. You hear him describe what happened to him as a tragedy. His own words, in real time. You hear him say to his mom that Professor Markel is not replaceable. They didn't want you to hear that. I want to go back briefly to the security cameras. Ms. Kappelman comes in here today and she talks about the times that Charlie went to the police. And she brings up examples of filing a lawsuit. She brings up an example of a dispute with a girlfriend. Those are very different than being told you have 48 hours to pay or you and your family are going to get killed. Especially taken in the context that just 9 hours earlier, Professor Markel was shot in broad daylight, executed. Reasonable doubt, a puzzle piece that just doesn't fit. Let's talk more about these wires. State's Exhibit 108, that's all the wires together. There's subparts of it. And I want to draw your attention to A, B, and C. These are the first 3 calls with Donna Adelson after the bump. And what you see on these calls is that initially, for at least the first call and a half, Charlie Adelson has no idea whatsoever what she's talking about. None. Now ask yourself, if you did a murder with someone, wouldn't that be the first thing on your mind? He has no clue what she is saying. He's talking about Yelp. He's talking about the IRS. He's talking about being sued. He has no clue. She says, it's about the 2 of us. We've already done this. We beat a horse to death on this. It's about the 2 of us. You were extorted, and now I'm being extorted. It doesn't even make sense under their theory of murder. By the way, on those first calls, she wants to meet with them when Wendi and Harvey are not around. I'm confused. I thought they're co-conspirators, according to the state. A puzzle piece that makes no sense. By the way, he starts to figure out what it is when she brings up blackmail. And when she brings up, and you can listen to it, you'll see the hesitation in his voice that he needs to bring cash when they meet the next day for lunch. He starts to figure it out. And what does he immediately shift his attention to? Don't take my word for it. You can listen to the wires. Was the guy white or Hispanic? Was the guy wearing a disguise? Was the guy threatening? Did he give you 48 hours? He's trying to figure out if it's the same people. they talk about why would he call Katie? His mom doesn't say anything about Katie, and he has other ex-girlfriends. Well, he has only one ex-girlfriend that on July 18th came to him and said, you have to pay money. I'm not part of this. Because if you don't pay money, they're going to kill you. And see, they ignore D 1392, part of the same exhibit. He slips. 3 minutes and 34 seconds into this recording, Charlie slips. See, he's got to be careful on these calls when he's talking to Katie, because he doesn't want her to think that he's setting her up and setting up her friend, whoever that might be. He doesn't know at this point. He has a guess, but he doesn't know. And the reason why he has to do that is because he needs her help. She's the one who is most equipped to help him figure out, is this a bad guy? Because if it's a bad guy, he's worried they're going to get killed. She says his first instinct isn't to pay. We're going to get to that. His absolute first instinct in Dolce Vita is to pay. You can listen to it. So he has to be careful in how he talks to her, but 3 minutes and 34 seconds into D 1392, he says the following. I mean, you didn't do anything with my mom. And she responds, what would I do with your mom? And he says, just checking. What could that possibly mean if he's not referring to the extortion? How could that possibly be talking about a murder for hire? It cannot be. 3 minutes and 34 seconds in, give or take, D 1392. Don't take my word for it. Listen to it. On the wires, Charlie Adelson's way of calming down his mom, and what he is hoping for is that it is the police. How does that make any sense if he did a murder? He did a murder, but he's hoping that the police are onto him? It makes no sense. See, he's hoping it's the police because he didn't do a murder. And if it's the police, no one's going to get killed. They went through Dolce Vita with you, and I'll probably go through it a little bit more with you later. But let me say this. Listen to it for yourselves. Think about the parts that they left out in their closing. How about the 9 times that he says something to the effect of, we have nothing to hide. We didn't do anything. How about the 36 times he says that on the wires? How about when he says in Dolce Vita, these people only know part of the story, or they think they know part of the story? What could he possibly be talking about if he did a murder for hire? What he's saying is, they think we did a murder for hire. They don't understand I was extorted. They think they know the whole story, but they only know part of the story. And that's why I hope it's the police. In Matsuri, he says twice, the funny thing is. Listen to it in the context. What's funny is they don't realize that the sting they put together is close to the truth. CP 2325, 7 minutes in. They opened on it. But they didn't want to play it for you. They skipped over it. It's in evidence. You can hear it. There's talk about it being someone not from the first layer, but probably the second layer. Talking about extortion. The first layer is when he was extorted on the evening of July 18th, and his payments for the 21 months. The second layer is the bump. He's trying to figure out, is it the police? Is it a copycat? Or is it the same guys? On the wires, who are the only people that call and speak with the undercover? They call from their cell phones. They don't make a big deal about star 67. They call from their cell phones. They don't get burner phones. The only two people that speak with the undercover, Charlie Adelson, Donna Adelson. Ask yourself why. Reasonable doubt, a puzzle piece that doesn't fit. Look at the text messages. Now, I fought to get in these text messages. Ask yourself why I had to fight so hard.
Judge, I'm going to object to Your Honor's rulings and
Sustained.
legal objections.
Please move on.
Look at the text messages that are in evidence. Nothing out of the ordinary. Everything explained. He didn't hide or flee. Not like Katherine Magbanua. Another lie she told you all. She said she didn't know it was the police outside. She didn't hide. You heard she hid. You heard she got a burner phone. II 1393, 1 minute and 47 seconds in. A call between Katherine Magbanua and Sigfredo Garcia. 1 minute and 47 seconds in, Katie tells Sigfredo that she's worried, in essence, that Charlie's parents, Donna and Harvey, are going to go to the police. If they're co-conspirators in a murder for hire, why would she be worried that they're going to go to the police? It doesn't make any sense. Simply put, these puzzle pieces and others do not fit the state's theory. Why? Because while they want to make this a simple explanation, while they use words in closing 13 times could, 6 times maybe, 2 times maybe not, 3 times suspicious, 6 times coincidence, that is not beyond a reasonable doubt. That is not what we do in this courtroom. We presume innocence. We don't guess. We don't ignore things that don't fit into the theory. Now I want to turn to the testimony at trial, and I will try not to be repetitive. The first group of witnesses, we asked very few questions. We don't disagree that the murder of Professor Markel was horrific. They showed you those pictures today. I can't look at them. These people that killed him were animals. We agree that the police work was phenomenal. That's why they caught the 3 people who did this. But you also remember, check your notes, that none of those original witnesses said a word about Charlie Adelson. Now, the first witness of substance was Agent Sanford. He came twice, so we're going to deal with him each time. The first time he came on the stand, let me say this. He's an honest and truthful guy. He's exactly what you want from a witness. Compare him to Katherine Magbanua. Compare him to Ryan Fitzpatrick. We'll get to that. They put in emails through him. And they showed that there was distress in the family, that there was anger over the relocation issue and divorce. They also showed that the relocation issue was denied in 2013, the summer of 2013, a year before the murder. We saw that there were very few emails from Charlie Adelson, although he was aware of some of the crazy emails. And he would say things like, "Good idea." We learned about the $1 million offer and how Charlie was going to pay 1/3 of the $1 million with the hopes of getting paid back. And we learned through Agent Sanford that there were emails that showed that this $1 million offer, the Adelsons consulted a lawyer on it to make sure they were doing things legal. We learned that in his experience, murders for hire aren't paid this way. We've already talked about that. And we learned that there is ongoing discussions about where the kids were going to go to school in the fall of 2014. Ask yourselves, why do you need those discussions if you know you're about to kill a guy and relocate? And then we heard from Wendi Adelson. And again, we spent a lot of time crossing Wendi Adelson because we wanted to show you that their theory on her was absolutely wrong. And one of the things I didn't mention earlier, in addition to the plane tickets and the hiring of a divorce lawyer and the scheduled meetings and the custody arrangements in August, you see in Defense Exhibit 6 that she's trying to buy a house. Now, they talk about a house on Halloween Halloween of 2013 that Charlie convinced her not to get. What about when she's looking for a house just a month or so before the murder? No evidence that anyone's trying to stop her then. She testified that she was not worried about disbarment. By the way, we called her lawyer to the stand to buttress her testimony because the same motion was made against her. And she testified she wasn't worried about disbarment either. She testified that she never made the $1 million offer or the Christianity email threats. We showed through emails, and they're on the wires, to support her testimony that after the murder, she was scared and sick. You don't have to take Charlie's word for it, and you don't have to take my word for it. It's on the wires. On the wires themselves, it talks about how Wendi is finally getting over this. We showed through stipulation that there's no way she and the kids could have been on the road the day of the 17th. And we showed that through her that Professor Markel posted in a lot of places about his travel. Now, we have no idea how Katherine Magbanua and Sigfredo Garcia knew where Danny lived and knew when he was going to be out of town. We don't know, because it has nothing to do with us. but we showed you possibilities of where the information could have been found. That, ladies and gentlemen, is the definition of reasonable doubt. As opposed to some crazy explanation, and we'll get to it, that just 3 weeks after dating, he put some letter in her bag that she doesn't know what the letter is about and what it says, but it must have been that. Does that make any sense? And we showed that on the day of the murder, Wendi Adelson voluntarily was interviewed for hours without a lawyer. She gave her phone. She let them search her car. She let them search her computer. And she named everyone who could have done this. Everyone that came to mind, the first person she named was herself. And yes, she mentioned the hitman joke. And then she said, but he wouldn't do it. By the way, talk about a puzzle piece that doesn't fit. His co-conspirator goes to an interview with law enforcement on the day of the murder and tells law enforcement about the hitman joke. Does that make any sense? It does if they're not co-conspirators. It does if they had nothing to do with the murder. Reasonable doubt. She talked about her problems in the relationship with Jeff Lacoste, how he was stalking her and jealous. It gave more reasonable doubt, and I would submit proved innocence. The next witness was Officer Brandon. His testimony was short, but indicative of the state's case. He testified that Wendi drove down Trescott. Again, she explained why. But more importantly, the state tried repeatedly to pound this evidence in to show that Katherine Magbanua made a phone call, got a phone call at 12:30 and said, I know it's already been done. Remember that testimony? And the state was desperate to say that that phone call somehow came from Wendi Adelson. But look at their own exhibit. The phone call is at 12:30. They showed it to you today. Look where Wendi Adelson is at 12:30. She's nowhere near the residence. According to the state's theory, she must have mind-reading ability. But yet they continue to try to pound that puzzle piece into place. They double down on it. Ask yourself why. Jeffrey Lacoste. The jury instructions will tell you to evaluate bias in witnesses in determining their truthfulness. It is not up for dispute that Mr. Lacoste was a jilted lover who was stalking Wendi Adelson. You heard that from Hale, Officer Hale, the later witness. More importantly, though, Jeffrey Lacoste thought that the Adelsons and Wendi had tried to frame him. He was upset about that. They thought he tried to frame them. He thought they tried to frame him for this murder. And so his testimony was shaped by that anger. The truth is, he had a nice time at dinner with Charlie on March 11th at Yardbirds. There's a text message in real time, unsolicited, confirming that. Charlie didn't send him a text, he sent Charlie a text. The truth is, when he talks about Charlie having associations with the Cuban element, whatever he testified to. By the way, no one in this case is Cuban. Tell you a secret, Sigfredo Garcia is not Cuban. Luis Rivera is not Cuban. Made up. He admitted that even though he supposedly thought Wendi was part of a murder, he would have gotten back together with her. Does that make any sense? He says that Wendi told him that Charlie really looked into hiring a hitman. He says she told him this when they were breaking up. Does that make any sense? He says that after they broke up, she told him it was a celebration dinner. Meaning she's telling him, I did a murder with Charlie. Does that make any sense? And then you hear about these notes. You hear it from Officer Hale and others, how there's a bunch of notes. He took a bunch of notes. I never saw the notes. You know why? He destroyed them. Ask yourself why. His testimony makes no sense, is biased, and should be discounted as nonsense. As someone who is angry because he thinks they tried to frame him. Stephen Webster. Honest. Nice. This was Professor Markel's divorce lawyer. But notice something. He's not a divorce lawyer. He's a criminal lawyer. Never litigated anything in the case. But yet they call him to try to bolster some sort of motive that Wendi Adelson was so fearful and the family was so fearful that she was going to be disbarred. That these motions were going to be successful. When I asked him, did you know that the judge was frustrated with Professor Markel? He had no idea, because he wasn't the lawyer at the time. Junam Chinda. She testified that Charlie sleeps with a gun. Why would he sleep with a gun if he was part of the murder? She testified that during the bump, she wasn't actually clear, but I'll give him this. During the bump and after that, he was upset. He was acting weird. Of course he was. He didn't know whether his family was about to get killed. He didn't know who was extorting them the second time. She also testified how Charlie flew out of the country and always returned. Ryan Fitzpatrick. To me, this witness sums up the state's case. And it's scary. He had no first-hand knowledge of anything. And you learn only through cross-examination that years after the murder, when he was about to be sued by Charlie, he threatened him to go to the FBI and say things bad about him. You learn that just days before coming in this courtroom, he's on a blog taking bets about whether he can cause him to serve the rest of his life in prison. Disgusting. Luis Rivera. The state still doesn't get it. I'm not going to discredit his testimony, just the opposite. To me, Luis Rivera's testimony was in some ways the most significant. He's an animal, but he was truthful. He said what he knew. It proved firsthand why you must find Charlie Adelson not guilty of all 3 counts. It proved firsthand reasonable doubt. It was an aha moment. Let me remind you of it. He admitted that Katie was the mastermind of the killing. He said that everything had to be cleared through Katie. He said that everything he and Sigfredo knew came through Katie. He said he wanted to do a robbery, but Katie said he couldn't do a robbery, that it had to be done this way. We went through all the lies that Katie told him through Sigfredo, the lady being on Trescott, the purpose of the trips, the amount of money. He now understood why he got $37,000 instead of $35,000. We went through the fact that he knew nothing about the payments over time or the gifts to Katie. And here was the punchline. When asked, could this have been an extortion and not a murder for hire? Could they have lied about that to you too? His answer was yes. One of the 2 shooters admitted to you that knowing what he knows now, this could have been an extortion. That, ladies and gentlemen, is the definition of reasonable doubt. Am I going to discredit him? No. I'd never talked to him before. The first time I met him was in this courtroom. Their witness says it could have been an extortion. Katherine Magbanua. Now, we've talked a lot about her already, and I don't want to talk about her much more. But ask yourself about all her lies. This Halloween nonsense. Go take a look at Defense Exhibit 34. Charlie Adelson knew nothing about Sigfredo Garcia on Halloween. You see it in text message on November 27th. They'll try to spin the text message. Read it for yourselves. Defense Exhibit 34. Her testimony alone should give you a mountain of reasonable doubt. Clarissa Liberato and Erica Johnston. The state called them to prove something we already admitted in opening. Katie didn't work at the Adelson Institute. Mary Hall. She confirmed the gifts, the payments for the car repairs. By the way, she confirmed that he put many of those on his credit card, creating a paper trail as well. Now let's talk about those gifts, because I want to make sure everyone understands it. Over time, Charlie became more and more convinced that Katie was not part of the extortion. But he needed her help. See, because as long as she was helping him, he knew he wasn't going to be paid a visit. As long as she was helping him, he knew the money wouldn't go up. And so he tried to keep her happy. Now, they want you to believe he tried to keep her happy because he was worried that she would go to the police and report a murder that they both did together. Does that make any sense? No, he tried to keep her happy because he wanted her to know he was appreciative that she was helping him. Investigator Corbett. a thorough witness, straightforward guy, honest. This is the phone analyst investigator. He looks at patterns. He doesn't know what's said on the phone. It's guesswork. He sees the frequency in the amount of calls. And he looks for patterns. Now, when asked, could these calls be because it's a boyfriend and a girlfriend, a mother and a son, husband and a wife? He says, of course. He also confirmed that there's an absence in records. That by the time they arrest Charlie Adelson in 2022, we can no longer get phone records before when they got him originally. We can no longer get SunPass records. SunPass records would show that Donna Adelson and Charlie Adelson, Donna Adelson and Harvey Adelson never were at Charlie Adelson's house that night. He confirms that. And he also confirmed that there were a lot of calls that are consistent with when Charlie is driving to work and coming home from work. Now, I want to talk about this landline issue because it is crazy. It may be the craziest thing in this case. And it's done to incite you. But when you think about it, you're going to see it means absolutely nothing. So they have a chart. She showed it in closing of frequency in using the landline, calling the landline. And you see that Charlie hardly ever calls his parents' landline. Okay? And they want to show you that on a particular day or days, he calls the landline. So that must mean something. What does it mean? He's using his cell phone. He's calling his parents' number that has been the same number since the year he was born. Grasping at straws. That's what that is. Then they confuse a wired call with those calls. What they're confusing is there's a call after Charlie. You'll see it go look at it. There's a call after Charlie learns about the text message that they sent to his mom at like 2 in the morning. You'll recall that he and his parents meet at the pool at their apartment. And you'll recall that Charlie then goes and he goes to a friend's office and he gets a call or calls Katie, and then he says, I'll call you from a landline. And that's because he doesn't get good service in that office. It has nothing to do with his parents' apartment. This landline, it doesn't mean anything. It's like magic. It's like they're putting on a magic show. Use your common sense. Corbett also confirmed that Charlie's house was a stone's throw away from the turnpike, and that the most direct route to Tallahassee for Donna and Harvey was to take the turnpike, which passes right outside his house. And he confirmed that Charlie didn't leave his house for more than 24 hours after the night he was extorted. They show you that Jim text. Corbett, their own witness, confirms he didn't leave the house. We're almost there. Special Agent Jimenez. No real substance. He pretends to be a Latin King gang member. This is important. when he does the bump of Donna Adelson. It's going to be critical that you hear that and understand that. He pretends to be a brother of Tato. And he testified up here that the reason why he did that is because he wanted the Adelsons to know that it was gang-related. Up until this point in time, we're now in 2016, April 19th, there's nothing about Latin Kings. No matter how many times Ms. Kappelman wants to ask Charlie about Latin Kings in 2014, or talk to you about Latin Kings in 2014, they're nowhere near this case in Charlie's mind until 2016. And more precisely, until April 20th of 2016. And we'll get there in a moment. But Jimenez testifies that he inserts this into the bump. Then we heard from Agent Bronstein and Keith McElvey. And we learned from them that only part of Dolce Vita is recorded. You saw it's difficult to hear. You can't hear almost anything Katherine Magbanua was saying. And we learned that there's numerous recordings. By the way, you have two of the recordings. I submit to you that the recordings are the exact same. You can listen to them for yourselves. But it's interesting where they started the recording that they played for you. And we know what he meant when he said that, because he never fled. You heard from Special Agent Sanford. He went to places far away. Extradition's tough. And he always came back. Investigator Kendall Matsuri. Probably my favorite question in the case that you didn't understand until later when I asked him whether he didn't like sushi. That's how they knew he was police. But he Sanford a second time. And they were called, they called him to put in all the wires. But he couldn't really talk about what the wires meant because he wasn't part of those conversations. Only two people could really talk about what they were meant. And frankly, I thought maybe we'd have a he said, she said case in this case. They didn't call Katherine Magbanua. You only have one version, the truth of what was said on those wires. And we'll get to that. Sanford the second time confirmed that Katie was hiding when the police came knocking on her door. She lied to you about that. He confirmed that Katie lied during her proffers, that he had to walk out. She lied to you about that. He confirmed that there was no evidence of any calls between Katie and Charlie after Sigfredo's arrest in the spring of 2016. He testified to the numerous lies that Katie told on the wires to Charlie and how she didn't lie to her co-conspirator, Sigfredo. That was their case in chief. We had no obligation to put on a case. When you're evaluating the presumption of innocence and whether they met their burden beyond a reasonable doubt, stop right there. They didn't come close. But we put on a case. We talked a little bit about lawyer Adelson. We can move on from her. I think you get the point of what her purpose was. But Charlie Adelson testified. And when he testified, you saw him explain on direct what happened on the 18th. How he was extorted. How he was fearful for himself and his family. You heard why he didn't go to the police. Now, listen, some of us might go to the police, some of us might not. You heard why he didn't go to the police. Reasonable. He had just seen what had happened to Professor Markel. He knew the danger of these people. And she wants you to think that he would negotiate with Katie that night. He was stunned. What was there to negotiate? And again, there's no counter-narrative because they didn't call Katie Magbanua and ask her about it. You heard why he thought Katie wasn't part of it and was protecting him. And you may remember Miss Kappelman trying to trick him. And he was clear. In 2014, he had no idea she was behind it. No matter how many ways she tried to ask the question. You saw him explain all the wires. I'm not going to do it here. I won't do that to you all. You saw him explain every word on Dolce Vita. You saw him explain what Dolce Vita was about. See, what you learn is that he met with his mom. And at first he thought this might be the same original extorter because he knew that Katherine and Sigfredo were having issues. And that made him nervous. But he also saw how different this was. And I apologize. I went over so many wires where it's the same thing over and over and over as to him trying to compare the two events. I did it for a reason. It wasn't to bore you. It was to show you in real time what was on his mind. And when he met with his mom, because of the differences, he was pretty certain it was the police. And he had no clue who Tato was. But then he meets with Katherine Magbanua in that car, and he freaked out. And you know why he freaked out? Because he learns that there is a Tato. He learns that he is not only in the Latin Kings, but is the head of the Latin Kings. He learns that he has brothers. Remember the bump? My brother is incarcerated, and he learns that Tato is incarcerated. And he thinks to himself, oh my God. And by the way, he also learns, which we now know is a lie, because again, Katie was trying to protect Sigfredo. He learns that Tato was the killer. He wasn't the killer. Sigfredo was the killer, Tutto. But in the car, he learns about the Latin Kings, he learns about Tato, and he learns that that is the guy that she told him killed Professor Markel. And you wonder why he's talking the way he's talking at Dolce Vita. He is freaking out. He thinks his mom, if they don't pay, is going to get killed. And if she doesn't get killed, someone else is. And so when they walk into Dolce Vita, that's what the debate is about. So you have to understand the context of the conversation. When they're talking about rental cars, it's because he's just learned about the rental car. When they're talking about dead gang members, it's because he's just learned about a gang member, Tato. And the debate is, he wants her to pay. And she's telling them, it's not them. It's not him. And the reason why she's telling him it's not him is because she knows who Tato is. You saw Tato. He'd be a little bit more threatening than the guy we saw in the video. And his associates would be a little bit more threatening than Mr. Jimenez. And through Dolce Vita, what you see is a couple things. And you can listen to it. Don't take my word for it. You see him trying to act tough. But then you see him quickly say, but I don't know anything. I'll keep my mouth shut. So he's acting tough. I'm carrying a gun. I'll shoot the gang member in my driveway. But I don't know anything. I'm keeping my end of the bargain from July 18th. I'm not going to say a word. This discussion about information and details. It's clear on Dolce Vita and on the wires what they're talking about. The details aren't details about a murder. The details are details about the payments. By the way, that's what they talked about when Jimenez came and did the bump. We know you've been helping. The payments. They leave out the fact that repeatedly he says, I don't care if it's the police because I've got nothing to hide. It's said in Dolce Vita. Discussions about the importance of the characteristics of the guy who approached them. He's using a real phone number. He's not wearing a disguise. He's not giving 48 hours. He's not being threatening. Again, we talked about it. They only know part of the story. Discussions about who he hopes it is. Hopes it's the police. And you see that contrary to what Ms. Kappelman said in closing, his absolute first instinct is to pay. He wants her to pay. And she doesn't want to pay. See, she knows it's not Tato. She knows it's not Sigfredo. And she's trying to convince him it's the police. And you'll see in the video, she goes to the bathroom. And by the way, he's been talking like this. He doesn't stop. She goes to the bathroom and he finally listens. And when she comes back, you see his conversation changes again. He says, okay, I see what you say. Here's the number. Call the number. But he starts talking about how it's different. And then he calls his mom, and he talks to his mom about how it's the police. And Matsuri is the same thing. Now, why they're talking in code, listen, I think this is semantics. There is no code, but we can agree on this. They are talking carefully. And the reason he is talking carefully depends on who he is speaking to. When he's speaking to Katherine Magbanua, he is speaking carefully because he needs her help. And he does not want to spook her. When his mom and him are speaking carefully, it's because he does not want anyone to know, including the police, about the first extortion. Because if they know about the first extortion, they're going to come talk to him, and he believes that he and his family will be in danger. And by the way, he doesn't go to the police because it's clear the police wouldn't believe him. Just like they don't believe him right now. Now, during Ms. Kappelman's cross of Charlie Adelson, you saw it. I'm not going to go into it in detail. But one thing is clear, is that he knew the wires cold. He knew dates. He knew what he said on particular wires. And you might ask yourself, why? His life is dependent on those wires. For the last year and a half, he's been in prison, jail. He's reviewed those wires because he knows they show what really happened. The wires show his innocence. And they certainly don't show proof beyond a reasonable doubt of his guilt. You know, like the landline, I want you to think about the bullet bourbon. Agent Maltese was told to take a picture of that bullet bourbon, done to incite. Thank God Wendi Adelson kept the invitation to the party. Not the simplest explanation, but the truth. The state's case is like that. The case against Charlie Adelson is a case of guesses and of assumptions. It was not brought until just weeks before Katherine Magbanua's second trial. 8 years after the murder, 6 years after the arrest of Sigfredo, and later Katherine Magbanua. The evidence wasn't there then, and it isn't there today to meet their high burden. The puzzle pieces do not fit. He did not participate in the murder of Professor Markel. He didn't do it. He didn't conspire to do it. He didn't solicit it. By the way, speculation can be reasonable doubt. You can go back there and speculate. You can use your common sense and figure out.
Your Honor, misstatement of the law.
Approach. Regarding the last comment concerning speculation, you may continue with your argument.
You're allowed to use your common sense. That's what you're allowed to do. That's what you're told to do. You don't have to check that in the door out there. The presumption of innocence means that we presume the best about people. We presume them to be blameless. That means when you're listening to these wires, if there are two possible explanations, you go with the one that is favorable to Charlie Adelson. That's what is consistent with the presumption of innocence. The state wants you to assume guilt. They want you to listen to these wires, and they want you to hear them in a certain way through dirty lenses. They want you to look at them through the lens of everything being wrong and sinister. That is not what the law says you should do. If you presume this man innocent, which the law says you must do, which is what each and every one of you gave your word you would do during jury selection, then you look at these wires and you listen to them assuming the best about Charlie Adelson. And when you have two explanations, both of them reasonable, you go with the one that presumes his innocence. That's how our system works. Reasonable doubt, the judge has instructed you on. And he's told you that reasonable doubt is if you vacillate, if you go back and forth, that either explanation could be right. If you waver at all, that is living, breathing proof of reasonable doubt. And when you find yourself doing that, you must find Charlie Adelson not guilty, because that is reasonable doubt and shows that the state did not meet its burden. Each and every one of you promised us during jury selection that you would have the courage, the fortitude, that if the prosecution didn't meet its burden, something they have not come close to doing in this case, that you would have the courage to say the words "not guilty." And that's what we're asking you to do, because simply put, the evidence isn't there. The evidence is actually consistent with innocence. Now, because of the state's high burden of proof, they get another closing. And I don't get to speak again. So I need each and every one of you, when they're speaking, to think in your minds, what would Rashbaum say? What would the evidence say? Remember, in our system, they don't get the last word. You do. I know you will take your jobs as jurors seriously. I know you will follow the law, the presumption of innocence, and the high burden of proof. If you do that, there is only one just verdict in this case. Count 1, not guilty. Count 2, not guilty. Count 3, not guilty. End this nightmare. Send him home. Thank you, Your Honor.
State prepared to give its rebuttal closing.
Yes, Your Honor.
You may proceed.
The defense has encouraged you to speculate in this case. The law does not allow that. I want to draw your attention to page 4 of your jury instructions. You don't have to pick them up. Page 4, middle of the page. Whenever the words reasonable doubt are used, you must consider the following. A reasonable doubt is not a mere possible doubt. Could it be? Not good enough. A speculative doubt. Speculation. We don't have that in the courtroom. We don't have that in the jury deliberation room. Imaginary or forced doubt. Not reasonable. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. When you're back there and you're thinking about what Mr. Rashbaum would have said, he would have said puzzle pieces. First puzzle piece, the motive doesn't fit because He had a great life and he wouldn't have wanted to ruin his life. The problem with that argument is arrogance. This was not an issue for him because he wasn't going to get caught, because he was untouchable. They said relocation had no impact on Charlie Adelson, and that they proved Wendi's innocence in their questioning of her. Why are they working so hard to convince you Wendi is innocent? Does it matter? Y'all aren't being asked to decide anything about Wendi Adelson. There's nothing on that verdict form about Wendi Adelson. Did she corroborate the defense theory in this case? Wendi Adelson testified she didn't know anything about this supposed extortion of her brother, even though she moved there the day this happened. She didn't know in 14, she didn't know in 15, and she didn't know until it was announced in opening statements in this courtroom. I asked her about it, and she said, quote, "Well, I learned that someone made that argument. I don't know whether it's true or not. I don't know whether it's true or not." Even his own sister doesn't believe this load he's trying to sell y'all. Garcia wanted to kill the defendant so he wouldn't have done a hit on his behalf. And for that they refer to the jet ski incident. They couldn't be in a conspiracy together because they hated each other. Well, that was part of the purpose of the walling off. The whole theory of this defense is that this defendant was so fearful of Sigfredo Garcia that he couldn't do the normal thing. He couldn't report this. But he continued to date Katherine Magbanua, Garcia's baby mama, after all this. After July 1, when they had this incident in the roadway. After the extortion. And even after that, he continues to send love notes to Sigfredo Garcia's woman. Even after the two of them get back together, he's still sending those notes because he's so arrogant. Defense has told you that the defendant made the joke about the TV being cheaper than a hitman to people he hardly knew. Who are those people? The only person that testified in this courtroom that they had heard that joke was Wendi Adelson. Lacasse was asked. The lawyer said they said it, and you guys have to refer to your notes and your own memories about what the evidence showed. But Lacasse was asked, did he say the joke at the dinner that y'all went to with Wendi and Garcia and Katherine Magbanua? I'm sorry, Wendi and Charlie and Katherine Magbanua. And he says, no. He does not recall that joke being made, and he thinks he would have recalled it had it been made. So there is no evidence in this trial that the defendant told that joke to people he hardly knew. If this was a murder for hire, it should have been paid in advance. Murder for hires always get paid in advance. That's what Pat Sanford said. That's not what he said. What Pat Sanford said is the arrests have been made close in time after the other murder for hire cases have worked. So there's no payment over time, gifts and stuff like that. Here, the investigation took years for the defendant to have the opportunity to try to keep her happy, to try to provide these gifts. Not only to her, but to Sigfredo Garcia. A gift card for a vacation on your extortion victim. Offered, not asked for, not demanded, offered. Offered to the extortionist. The defense talked about Katherine Magbanua. He hates when people lie, and she's a liar, and she lied to you. Well, Mr. Rashbaum's opinion about the witnesses. He told you which ones were good, which ones were lying, which ones were truthful, which ones were the best ones, which ones meant nothing. You guys decide that stuff, okay? What we say is not evidence. Katherine Magbanua is a liar, though. I mean, she said other stuff, and now she's saying this. You guys have to consider that. That's a no-brainer. She has played every card she had, and this is the last stop for her. I agree with that. You guys agreed at jury selection that you would keep an open mind to that type of evidence, and that's all I ask you to do. Does it fit with the other evidence in the case? Because her last testimony sure didn't. Nobody has stronger feelings about Katherine Magbanua than the ones sitting on this side. Would I ask you to base this defendant's freedom on the word of Katherine Magbanua? That's what they said I'm doing, and I would never do that. Never. Does it fit with the other evidence in the case? That's what I'm asking you to consider. I didn't ask her about Dolce Vita. She verified the transcript. She said the words that scrolled when y'all watched it were the words that were said. The state has a doubt. What if we do? It doesn't matter. Doesn't matter what the lawyers think. Doesn't matter. Do you have a doubt? Doesn't matter what I think. Doesn't matter what Mr. Rashbaum thinks. Regarding the defendant's demeanor in 2014, the defense said there was nobody that said anything about his demeanor. We only asked about, was he going crazy after the bump? And the answer was yes. That's not true. Ryan Fitzpatrick, who was his best friend in 2014, they didn't fall out until 2015, reported no change in his behavior. I said, was his behavior weird like that before the bump? No, not weird. That was his quote. He was normal until the bump, and then he was agitated, angry, freaked out, tense, stressed, whatever. Why didn't I play all of the calls? Did y'all get enough of the calls? It's trying to pick the parts that I think are important. They're in evidence. Feel free to listen to them. I do not want you to think I was trying to hide anything from you. Those are in evidence. And you will have an opportunity to review anything you want when you're back there with the recording equipment, headphones, and all that will be provided to you. The defense says in calls A, B, and C, if you did a murder with someone, wouldn't it be the first thing on your mind to report? Well, maybe, but you're probably not like Charlie Adelson. You're probably not untouchable. Charlie Adelson asks the description on the wire, tell me about this guy, what's the timing, what was he wearing a disguise? How do those questions, the defense is offering that as evidence that he was trying to deduce whether this blackmailer was the same as the prior blackmailer, but he never saw the prior blackmailer. He only saw Katherine Magbanua. So how does asking if the guy that approached his mother was wearing a disguise tend to prove his innocence or tend to prove his extortion theory? The guy that extorted him wasn't wearing a floppy hat and an Abe Lincoln beard. It was Sigfredo Garcia. It was Katherine Magbanua. Sigfredo Garcia, the first extortionist, didn't give him 48 hours to pay. He put him on a payment plan. He paid over years. The defendant, hoping it's the police, and saying, quote, these people only know part of the story, or they think they know part of the story. The defense picks that out and says, oh, there he is talking about the first extortion. Or is he saying, why did they go to my mom instead of me? I'm the one that has a connection to you. I'm the one that, I think what he says is, I'm the one that has a relationship to you. Why didn't they come to the one that's involved? I mean, I'm not involved. That's what he says. Why didn't they come to the one that was involved in this? That's what he's trying to figure out about why they went to his mom and not him. Can't even read my own writing here. Oh, the PowerPoint with Wendi. Okay, the dots on the cell phone PowerPoints do not indicate where the person was. They indicate the cell tower that was servicing the person's phone at that time. So they're going to be somewhere around there. And the testimony was that Wendy's dot at 12:30 could be consistent. He can't say where she was. Could be consistent with her being at Trescott, and we know she went to Trescott because Officer Brennan observed her there. So I'm not desperately trying to pound a puzzle piece into y'all that Wendi made the call to say it's done. I don't know that. I can't prove that. If that information was conveyed, I don't know how it got conveyed. All right, Lacoste. They really need y'all to discount the testimony of Jeffrey Lacoste, right? Because of that statement that Wendi made to him just before the murder, that all kidding aside, her brother really had looked into hiring a hitman to kill Dan Markel. And the defense says, you can't believe him, he's a jilted lover. And the evidence definitely showed that he was heartbroken over Wendi Adelson. But unfortunately for the defense, his brain was working just fine. And he testified about Charlie Adelson bragging in the hot tub about connections to a Cuban criminal element. The defense says, oh, they're not Cuban, that's not in evidence. They're of Hispanic descent, and he reported that to law enforcement that that's what Charlie said. Lacoste doesn't know if they're Cuban or something else. Lacoste said he bragged in the hot tub about having connections to a Cuban criminal element, and when Lacoste reported that information, the killers had not been identified, so he had no way of knowing if they were Cuban or of Hispanic descent. That's the importance of that. Lacoste says Wendi reported the celebration dinner, same thing. He comes in and tells the cops, look, she reported a celebration dinner to me where she vomited on the table. An inspection of the records proves there was a dinner and she did vomit. But they want you to believe that Lacoste is just lying about the celebration part? The Halloween text. They've asked you to look at their piece of evidence that talks about when Garcia learned about the existence of Charlie. That doesn't shed any light on what we're saying occurred on Halloween. On Halloween, Charlie, this defendant, approached Katherine Magbanua about, do you know anyone that can rough him up? Okay, we're not alleging that she called Garcia that day and said, hey, can you come kill somebody? That was just the first inquiry into a plan that developed over time between Charles Adelson and Katherine Magbanua. All right, the defense mentioned Erica, and I'm almost done. Erica Johnson and her testimony, that didn't mean anything. Why did they call them? What about that recorded call between the defendant and Erica? Why does he tell her not to talk to the police? What about June Mchinda? Why does he tell her not to talk to the police? They don't know about the first layer of extortion. They can't reveal the first layer of extortion that will reveal the second layer of extortion that will expose him to the Latin kings. Why is he telling them not to talk to the cops? Defendant's testimony. They say it's reasonable that he didn't go to the police with the truth because he had just seen what these people were capable of. They killed Dan Markel. He was in fear. Okay. Is that consistent with what you know about him? I refer you back to the wires and everything you know about him. But also, why then not come forward with this story when the bad guys were arrested and the danger was eliminated? Why not come forward when Katherine Magbanua was arrested and he believed her to be innocent? For 3 years she awaited trial while this man thought she had nothing to do with it, according to him. Yet he did not come forward with this story. Why not come forward after her conviction? All the bad guys have been arrested and convicted. Danger eliminated. Come tell the truth. He doesn't do it. What about after his own arrest? He doesn't come forward then. We learn it in this courtroom in opening statement. Defense says the defendant freaked out in the car before Dolce Vita. Right? You have to watch Dolce again and see if you think he was freaking out or if he was in control of that situation. He was the one giving orders in that situation. I'll go back to the players in this case being smart. I mean, the defendant is smart. And they had over a year to carefully plan this murder with the goal of not getting caught. And he's had 7 years to think about his defense in this case since the case first broke. And he does think he's untouchable. Don't guess. Don't assume. Look at the evidence. It will tell you everything you need to know. But don't let the way the defendant thought he would get away with this be the reason he gets away with it. As long as you keep your mouth shut, you can get away with murder. Well, fortunately for us, the defendant didn't take his own advice. He did take the witness stand. He did offer statements, and you are able to assess his credibility as part of your determination of this case. Only one of us is putting on a magic show. It's up to y'all to figure out which one it is, right? We just hope and trust that you all have the common sense and the courage to see this case for what it is, to cut through all the stuff that the lawyers say and get to the meat of it and render a verdict that does justice for Dan Markel. And that is a verdict of guilty as charged. Thank you.
In just a few minutes, you will be taken to the jury room by the bailiff. The first thing you should do is to choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when all of you have agreed on a verdict and to bring the verdict form back into the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberation should stop until the juror returns. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication, such as a blog, Twitter, email, text message, or any other means. Do not contact anyone to assist you during deliberations. These communication rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instructions I have given in this case, you must tell me by giving a note to the bailiff. Many of you have cell phones, tablets, laptops, or other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room. Kindly leave your devices on your seats where they will be guarded by the bailiff while you deliberate. If you need to communicate with me, send a note through the bailiff. If you have voted, do not disclose the actual vote in any note. If you have a question, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions, if I can, in writing or orally in open court. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. The audio, cell phone, summary, disc, jump drives, photographic, and video exhibits will be sent into the jury room with you when you begin to deliberate. If you wish to see any other exhibits, please request that in writing. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate the rules we all share. Before the bailiff takes you back to the jury room, I'm going to have the clerk announce our alternates, and they will be dismissed at this point. I did want to say, though, to our alternates, I thank you for your diligent service throughout this trial. This is certainly a circumstance where 2-week trials are not the normal, but we thank you nonetheless for your service in this matter. Madam Clerk?
Yes, sir. Our alternate.
Your belongings. If you wish to know the outcome of the trial, you may contact my office and we will respond. For the rest of the jurors, you may take your notepads with you. Please leave the copies of the jury instructions, but you may take your notepads and I believe your audio recording lists as well. This would be the point where everyone rises for the jury. They're coming out. Everyone can be seated. The attorneys can leave their phone numbers with the clerk. From here, we will be in recess unless there is a note or we have a verdict itself. Please leave your phone numbers with the clerk. We're in recess. Everyone can be seated.
Meeting our client.
They still bringing up Mr. Adelson? All right, for everyone in the gallery, once the verdict is read, if there can please be no expressions, either of shock or anger, please have no reaction at all. We're going to thank the jury for their service, and then they'll be dismissed. But again, it's very important not to either praise them or be negative concerning whatever the outcome of this is going to be. If you don't think you can control yourself, please step outside now so it does not become an issue. Jury comes in, remain seated. Everyone else, please rise. Everyone but the foreperson can be seated. Has the jury reached a unanimous verdict?
Yes, Your Honor.
If you please could hand the verdict form to the bailiff. The verdict form is in its proper order. Madam Clerk, please publish the verdict.
In the Circuit Court of the Second Judicial Circuit in and for Leon County, Florida, the State of Florida versus Charles Adelson, case number 2016 CF 3036B, verdict. Count 1. We, the jury, find as follows as to count 1 of the indictment, first-degree murder. The defendant is guilty of first-degree murder. Count 2. We, the jury, find as follows as to count 2 of the indictment, conspiracy to commit first-degree murder. The defendant is guilty of conspiracy to commit first-degree murder. Count 3. We, the jury, find as follows as to count 3 of the indictment, solicitation to commit first-degree murder. The defendant is guilty of solicitation to commit first-degree murder. So say we all this 6th day of November, 2023.
Does the defense wish for the court to poll the jurors?
Yes, Your Honor.
Juror Moore, was your verdict and the verdict of the jury as a whole just announced?
Yes.
Juror Brazos, was your verdict and the verdict of the jury as a whole just announced?
It was.
Juror Gardner, was your verdict and the verdict of the jury as a whole just announced?
Yes.
Juror Strawn, was your verdict and the verdict of the jury as a whole just announced?
Yes, sir.
Juror Kraft, was your verdict and the verdict of the jury as a whole just announced?
Yes, Your Honor.
Juror Milne, was your verdict and the verdict of the jury as a whole just announced?
Yes, sir.
Juror Hawley, was your verdict and the verdict of the jury as a whole just announced?
Yes, sir.
Juror Thorne, was your verdict and the verdict of the jury as a whole just announced?
Yes, sir.
Juror Brim, was your verdict and the verdict of the jury as a whole just announced?
Yes, sir.
Juror Williams, was your verdict and the verdict of the jury as a whole just announced?
Yes, sir.
Juror Douglas, was your verdict and the verdict of the jury as a whole just announced?
Yes, Your Honor.
Juror Platt, was your verdict and the verdict of the jury as a whole just announced?
Yes, Your Honor.
Members of the jury, I'm going to give you one last brief instruction, and from here, you will be discharged from your service. On behalf of the parties, the lawyers, and the people of the state of Florida, I want to thank you for your time and consideration of this case. I'm also going to advise you of some special privileges that are enjoyed by jurors. No juror can be required to talk about the discussions that occurred in the jury room, except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain a private affair for as long as they wish it. Therefore, the law gives you a unique privilege not to speak about the jury's work. The lawyers and their representatives are not permitted to initiate any communication with you concerning the trial. However, you may speak to the lawyers or anyone else about the trial if you desire. You also have the right to refuse to speak with anyone. A request may come from those who are simply curious or from those who might seek to find fault with this decision. It will be up to you to decide whether to preserve your privacy as a juror. We give you our sincere thanks for the work that you have performed over this 2-week trial. You are discharged. Have a wonderful evening. Everyone may be seated. Mr. Adelson, you are going to be remanded pending sentencing at this time. Does the defense wish to have a pre-sentence investigation report prepared as to counts 2 and 3?
Yes, Your Honor.
Very well. The court will order that the pre-sentence investigation be prepared by the Department of Corrections. believe it will take possibly a month. I'm not sure if it will take longer than that. From there, will the parties be prepared to move into sentencing? Tracy, does my
Prepared to present victim impact tonight, but as you know, the family members have traveled a great distance, so we're hoping Your Honor will permit them to appear and make those statements by Zoom whenever we're reconvening for sentencing.
that will be permitted? Anyone who wishes to provide testimony for the sentencing portion may do so over Zoom. I believe this does not implicate any right of confrontation unless the defense has something to raise concerning that matter.
No, Your Honor.
Very well. We are in recess at this point. Oh, yes. We are going to wait until the jurors have vacated the courthouse, and from there, everyone will be dismissed. Go ahead and set a case management date as a status. This will ensure that we have the PSI in place. That will be on December 12th at 2:30 in the afternoon. If everything is prepared, we can go ahead and have the final disposition on that day as well.
Yes, Your Honor.
Have a good night, everyone.